All right. And in the spirit of flexibility from the plaintiff, do you have any issue with the defendant not being able to log on until a little while?
No, Your Honor.
No, Your Honor.
Okay. Am I correct in understanding that's the way you want to proceed, defense?
That would be ideal, Your Honor. Thank you so much, and thank you to opposing counsel.
Okay. I'm hoping she'll be able to, she or he will be able to get that sorted out. But in the meantime, I'd like to get started. Are all parties prepared to begin the trial?
Yes, Your Honor.
All right, fantastic. Now, before I get into entries of appearance or anything at all, I do want to just go over some basic Zoom etiquette, which I'm sure we've all become aware of in today's age. When anyone else is speaking, I expect that all parties will have their microphones muted other than the speaking party. That includes even if you anticipate that you're going to be objecting or something like that, you just press unmute and then you object and then you press mute again. I guess the exception to that is if you are questioning a witness. I think both the witness and the questioning party can both be unmuted at the same time. On that same note, when somebody is giving an opening statement or a closing statement, I'm going to ask that all parties other than the speaking party close their or stop their video and remain muted. I think that gives us a little bit of the same feeling of somebody having the center of the well, at least as well as we can simulate in this this new technological environment that we're all working with. So with that, can I please get an entry of appearances from both parties, beginning with the plaintiff?
Good morning, Your Honor. My name is Rebecca John, last name spelled John. Here on behalf of the plaintiff, Cam Donaldson, who is also on the call with us today.
Good morning, Your Honor. My name is Morgan Mays, last name spelled Mays, here representing Cam Donaldson, the plaintiff, and we have some housekeeping matters we'd like to address, as well as a motion to eliminate when you're ready.
Okay, we'll go ahead and address those matters piecemeal after defense gives me their entries as well.
Good morning, Your Honor. My name is Jack Ayers, appearing on behalf of the defendant, Karen Beja. I'm joined by co-counsel.
Good morning, Your Honor. Enrico Trevisani for the defense.
Thank you, everyone. From time to time, as I'm sure you've noticed already, I'm going to be taking some notes. So if I'm paused or if I appear to be looking off screen, it's not because I'm ignoring you or anything like that. It's because I'm trying to take notes to make sure that I'm keeping track of everything as best I can. With that in mind, let me ask the scoring jurors, Ms. McManus, Ms. Stackow, or Mr. Braun, do any of you have any conflicts of which you are aware?
I do not have any conflicts.
I do not either.
I do not.
Okay, and nor do I. So with that, let me check with both parties, with both sides. Is everyone ready to proceed?
We are, Your Honor.
Okay, fantastic. The live stream is up and running so that the public can access this courtroom without being able to interrupt our proceedings. If I can have everyone raise their right hand. Do you all swear? Actually, we'll do it this way. Please indicate by saying I do if you swear to abide by the rules of this proceeding and to conduct yourself in a manner that is honorable to this forum.
I do.
I do.
All right, thank you. I do as well, for the record, and I'm sure that our scoring jurors do too. Now calling case number 082263, Cam Donaldson versus Karen Beja. Just to check with the parties, am I pronouncing both of those names correctly?
The plaintiff is pronounced correctly.
Yes, Your Honor.
All right, thank you. I just want to be respectful as I can be and make sure that I'm getting everyone's names right. Let's go on to housekeeping matters at this time. Does the plaintiff have any housekeeping matters that it would like to address?
We do, Your Honor. During the course of this trial, counsel may ask to approach for a sidebar. We ask that this be done constructively and we be allowed to remain on the video conference so that all evaluators will be able to hear our arguments.
Yes, I think that that's the most effective way to do this. I just ask that you actually ask to constructively approach when the moment is appropriate. Is that okay with everyone?
Yes, Your Honor.
All right, and I'm getting nods from the defense, so I'm going to assume that that's an affirmative. Any other housekeeping matters from the plaintiff?
Yes, Your Honor. May we be permitted to stand during opening statements and closing arguments while remaining seated for our direct and cross-examinations?
That's a great question. Because of the forum, because this is a Zoom trial, I think that some flexibility is warranted. If you want to sit while you're giving your opening statement or closing statement, that's okay. If you want to stand, that's okay. I also expect that some of you will have some questions coming up here about your use of technology. So I'll just go ahead and address that now. If somebody wants to share their screen for the purposes of publishing an exhibit or something like that, I'm going to go ahead and allow that. I just ask that you ask permission first as well.
Yes, Your Honor. Would you prefer us stand for objections or remain seated and closer to the video conferencing camera?
That's up to you. I think that the paramount, the thing that is of most importance here is that we all keep a clear record. So if that means you need to stay close to your microphone so that any appellate issues are recorded for the record, then that's okay.
And would Your Honor prefer that we formally tender our expert witnesses in this case?
Yes.
And lastly, Your Honor, just to confirm with the court and opposing counsel, we intend to use an exhibit in an opening statement, and we'd like to confirm there's no objection. We intend to use the exhibit that was pre-marked as Donaldson Deposition Exhibit 1, which can be found on page 27 of the PDF, or the first page following the Donaldson deposition.
From the defense?
We have no objection to that, Your Honor.
All right, then sounds like it's a stipulation and I don't need to be a party to the decision.
Thank you, Your Honor. That was all of our housekeeping matters.
Thank you. I had to pause for coffee. It's really important at this time of morning. From the defense, any housekeeping matters?
Yes, Your Honor. First, our understanding is that you received an electronic notebook containing the full case packet. We just wanted to confirm that that was true.
It is. It's my preference to reference it as little as possible. I prefer that for the purposes of the record that we're making here today, that you are as specific with your references to any case packet material, any depositions, any exhibits as you can be.
Secondly, Your Honor, the defendant is in the waiting room and should be able to join.
That's a very good thing. It is a trial involving him or her. So I'm glad that the defendant is present.
With that, Your Honor, we're ready to proceed to substantive motions.
Very good. We'll begin with the plaintiff. Any substantive motions in limine from the plaintiff?
Yes, Your Honor. Your Honor, we are here today because the defendant, Karen Beja, killed her husband, forged his will, and stole all of his assets. Your Honor, our first and only motion today is to exclude two photos which came up in the discovery process, which appear to be debris floating into water of some kind. Nobody will take the stand today who has any personal knowledge as to what these photos are, where they were taken, or who took them. Therefore, we move to exclude them as lacking in foundation and unduly prejudicial under the federal rules of evidence. And Your Honor, these photos can be found in the 9th and 10th page of the exhibit packet, as well as page 61, 62 of the PDF. And if it would please the court, my co-counsel could share the exhibits with Your Honor.
I don't need to see those at this point, unless it becomes a big issue. From the defense, is there an objection to this motion in limine?
No objection, Your Honor.
Okay, sounds like another stipulation, so I don't need to be a party to this. The exhibit will not be coming in.
Thank you, Your Honor. With that, plaintiff is ready for trial.
All right, thank you, sir. From the defense, are there any substantive motions in limine?
Yes, Your Honor. The defense has one motion in limine. We move to exclude Ms. Beja's misdemeanor conviction for assault as improper character evidence under Rule 404 of the Federal Rules of Evidence. This conviction doesn't fall under the 608 or 609 exceptions because it's not a crime of dishonesty, it's not a felony, and Ms. Beja was a juvenile at the time of this conviction. So we move to exclude any reference to this conviction throughout today's proceedings.
From the plaintiff, is there any objection to this misdemeanor conviction being precluded from coming into evidence?
No objection, Your Honor. Plaintiffs at this time do not intend to offer this information.
Okay. Yet another stipulation. So again, don't need to be party to this. I know it's a little bit difficult for everyone to actually get together ahead of time to discuss these things. But in the future, I would hope that y'all would confer as much as you can. Again, understanding that the flexibility is a little limited given our forum. So with that in mind, does the defense have any other substantive motions in limine that it would like to address with the court?
No, Your Honor. With that, we're ready to proceed to opening statements.
Fantastic. So as I mentioned before, I just want to remind everyone that I'd request that all parties other than the speaking party turn off their camera and microphone during opening and closing statements. I'll be doing that as well. Who will be giving the opening statement from each party?
I will be doing it for plaintiff, Your Honor.
And myself for the defense, Your Honor.
All right, thank you. Mr. Mays, as the plaintiff, you get to go first. So please proceed with your opening statement.
May I have a moment to adjust my camera?
Of course.
Your Honor, may I proceed?
Yes, you may. Thank you very much, Mr. Mays.
20 years ago, Lou Donaldson met a woman that would steal his heart, steal his life, and steal his company. That woman is the defendant in this case, Karen Beja. Now, this case that brings us together today was filed by Cam Donaldson, Lou Donaldson's daughter, on behalf of her late father. In the summer of 2012, Cam Donaldson's world came crashing down. In the span of a few days, her father went missing without a trace. Her stepmother, the defendant, stole Mr. Donaldson's will and then presented a forgery, and then proceeded to take over the Donaldson family business, the Wild Wildlife Emporium, firing Cam Donaldson in the process. The defendant took Cam Donaldson's father, took her job, and took her inheritance, but what she can never take is Cam Donaldson's right to seek justice. Good morning, members of the jury. My name is Morgan Mays, and here with my co-counsel, Rebecca John, we are proud to represent Cam Donaldson. And before we go any further, I'd like to introduce you to her. Cam, will you please come join us? This is Cam Donaldson. Her and her father had a close relationship from the start. This is Lou and a young Cam Donaldson. For 20 years, they were able to work side by side, working to save and preserve big cats. She was able to spend quality time with her father almost every day of the week, and her life has been completely changed by her father being taken away from her. Thank you, Cam. Now, members of the jury, the issue before you to decide today is whether the defendant will be held responsible for the death of Lou Donaldson, and for you to determine what is the value of a relationship between a father and a daughter. As the party bringing this lawsuit, we have the burden of proving by the greater weight of the evidence that it was the defendant's actions that caused Lou Donaldson's death. This is a burden we gladly accept because the evidence will show this by proving two things. First, Lou Donaldson provided the defendant with a better life. And second, she killed him to keep it. So let's talk about that first thing the evidence will show. Lou Donaldson gave the defendant a better life. To truly understand this case, we have to go back about 20 years ago when Lou Donaldson first met Karen Beja. At that time, Lou Donaldson was a successful businessman, married with a child. The defendant was single and broke. You'll even hear from the defendant today that she came from a poor upbringing and describes meeting Lou Donaldson as being rescued by her Prince Charming. Fast forward, the two eventually married, but then fast forward 11 years and their marriage was on the rocks. Lou Donaldson wanted a divorce. The defendant had threatened to kill him and Lou even went so far to file a temporary restraining order to try to stay away from her. You'll learn today that writing was on the wall for their relationship and that a divorce would have changed everything for Karen Beja. A divorce would mean she'd lose her cats, her man, and her money. The evidence will show she made her choice. Get rid of the man and keep the cats and the money. That brings us to the second thing the evidence will show. Karen Beja killed Lou Donaldson to keep a life that she thought she deserved. So with Lou Donaldson disappeared, she took over his life's work at the Wild Wildlife and secured 2 big pots of money: Lou Donaldson's life insurance policy and his estate. You'll learn today that Lou Donaldson was last seen on a Friday. Fast forward 48 hours, and less than 48 hours rather, Karen Beja breaks into the offices at the Wild Wildlife in the early morning hours and sets off the alarm. Cam Donaldson races down to the scene to check on the location. And what does she see when she gets down there? But the defendant walking out of the Wild Wildlife offices, holding a lockbox that was kept in Cam Donaldson's desk next to a man holding lock cutters. You'll learn today that in that lockbox was Lou Donaldson's true last will and testament. And the evidence will show that this document presented by the defendant today is not the same will that was in that lockbox. She broke in on a Sunday, took over the business on a Monday, and fired Cam Donaldson soon after. The cats, they were now hers, and she's gotten rid of everybody that would stand in her way. So you'll learn today about this alleged will presented by the defendant that had never been before seen by Cam Donaldson or her family. You'll hear from Taylor Pride, who is a forensic investigator and handwriting specialist who conducted an investigation and determined that this will presented by the defendant was fraudulent, and Mr. Donaldson's signature on that will was forged. With Lou Donaldson gone and the Wild Wildlife in her hands, the last step for the defendant was to get the money. And you'll learn today that she had Lou Donaldson declared dead and then immediately collected on his $5 million life insurance policy and officially inherit his $5 million estate. Now, members of the jury, at the end of this trial, my co-counsel will stand before you and ask you to determine the value of a relationship between a father and a daughter, where it might seem truly impossible to compensate a daughter for the premature loss of her father. I ask you today, listen to the closeness of their relationship. Listen to the dinners Cam will not be able to have with her father. Listen to the job she lost and the family business that was taken away from her. The evidence will show the defendant stole Lou Donaldson's heart, stole his life, and stole his company. And that is why at the end of this trial, we will ask you to return the only verdict consistent with the evidence required by law and demanded by justice, a verdict finding the defendant, Karen Beja, liable.
Thank you, Mr. Mays. Does the defense wish to present an opening statement?
Yes, Your Honor.
All right, thank you, Mr. Ayers. Please proceed at will.
May I proceed?
Yes, Mr. Ayers, thank you for asking.
May it please the court. This wasn't a crime. It was a crash. It's late on a Friday night. And Lou Donaldson is in his favorite place in the world, the cockpit of a twin-engine Cessna airplane. Altitude, 10,000 feet. All he can hear is the whir of the propellers. All he can see are the stars. And then the plane starts to shake. He's hit a spot of turbulence. But he's not worried. You see, he's been flying for 40 years. He just needs to check the pressure gauge. So he reaches for his glasses. But they're not there. He forgot them. Members of the jury, after Lou Donaldson took off on August 17th, 2012, no one ever saw or heard from him again. But the evidence will show that's not because his wife killed him, disposed of the body, and managed to do so all without leaving a single speck of evidence. You'll learn that the explanation is far less sensational. An older man, flying alone, flying late at night, flying without his glasses, never came home. This wasn't a crime. This was a crash. And today, we represent Karen Beja. A few moments ago, the plaintiff, they tried to describe her to you, but I want you to meet her. Miss Beja, could you turn on your camera? This is Karen Beja. 19 years ago, she was hitchhiking down the side of the road when a man pulled in to give her a lift. Lou Donaldson. They were married just a year later. That marriage was volatile, but Miss Beja will tell you she adored her husband. And in 2012, they were trying to make it work. When he disappeared, she was devastated. It's been 8 years. She never remarried. Thank you, Miss Beja. Now, of course, as the defense, it's not our job to prove Miss Beja's innocence. As the defense, we bear no burden of proof. The plaintiff and the plaintiff alone bears that burden. They have to prove every single element of their case more likely than not. And they will fail to meet that burden today because of two simple facts. This wasn't a crime. This was a crash. So let's take those one at a time. The first fact you'll discover is that this wasn't a crime. Let's go back to the plaintiff's opening statement. Let's talk about some words you didn't hear them say. Crime scene, eyewitness, murder weapon, blood, DNA, fingerprints, police. Now, members of the jury, you'll learn that the police, well, they investigated Karen Beja. You'll learn that the insurance company sent their own investigator. You'll learn that the plaintiff even hired a private eye. But they found no evidence, none, that Miss Beja killed Lou Donaldson. In fact, you'll learn they found no evidence that anyone killed Lou Donaldson. It's been 8 years. No one's found the body. Today, the plaintiff is accusing Miss Beja of killing her husband. But after 3 separate investigations, you'll learn that Miss Beja's never been charged, never been arrested, never even been named as a suspect. That brings us to the second fact that you'll discover today. Lou Donaldson died in a plane crash. Now, Lou Donaldson, he loved to fly. He owned his own planes. He flew his own planes. He'd been flying for years. Sometimes he took short flights. And sometimes he flew out over the Gulf of Mexico all the way to Central America. But he always flew alone. And he usually didn't tell anyone, not his friends, not his family, not air traffic control, that he was going. You'll learn, members of the jury, that on August 17th, 2012, Lou Donaldson left the office in a van. The police, they searched everywhere for that van. They searched his home, they searched around his office, and they searched all around town, and they found it. Parked at a private airstrip next to a runway. And sitting in the front seat of that van were Lou Donaldson's glasses. Members of the jury, the evidence will show that this is why no blood was found at Karen Beja's home. This is why no one saw Karen Beja commit any crime. The evidence will show that this is why no one's ever found Lou Donaldson's body. The police, they searched his home, they searched his office, but they never searched the 2,200 miles between here and Central America. Members of the jury, both sides here agree on one thing. This case, it's a tragedy. Lou Donaldson lost his life. The plaintiff lost a father. Karen Beja lost a husband. But this tragedy involved no treachery. At the end of this trial, we will ask you to find in favor of Karen Beja. Because this wasn't a crime. It was a crash. Thank you.
Thank you to both parties for your opening statements. Now we will begin with the plaintiff's case in chief if it wishes to put on any evidence, witnesses, or otherwise address the court. Mr. Mays or any other representatives from the plaintiff, do you wish to bring any witnesses before the court?
Yes, Your Honor. Plaintiff calls Cam Donaldson to the stand.
Good morning, Ms. Donaldson. Can I please have you raise your right hand? Do you swear to tell the truth?
Yes, I do.
Good. All right. Mr. Mays, you may proceed with questioning. First, Mr. Is it Trevisani?
Yes, Your Honor.
Okay. Mr. Trevisani, will you be addressing any objections or cross-examination from Ms. Donaldson?
Yes, Your Honor.
Okay, great. Thank you for that information. Mr. Mays, please proceed.
Good morning. Please introduce yourself to the jury and tell us all where you're from.
Good morning. My name is Cam Donaldson, and I'm from right here in Statesville.
Are you familiar with a man named Lou Donaldson?
Yes, he was my father. He passed away in 2012.
Your Honor, I have a photo which appears to be a young girl and a man. May it be marked as Plaintiff Exhibit 1 for identification?
Yes, you don't need to ask me to mark the exhibits beforehand. Just go ahead and state what it's been pre-marked as, and we'll go from there.
Yes, Your Honor. It's been pre-marked as Donaldson Deposition Exhibit 1, the same exhibit we showed in our opening statement. Ms. Donaldson, do you have a copy of Exhibit 1?
I do, yes.
For identification, do you recognize it?
Yes.
What is it?
It's a photo of my father and I from when I was young.
Is this photo is substantially the same condition as last time you saw it?
Yes, it is.
Plaintiff moves Exhibit 1 into evidence.
Any objection?
No objection.
So admitted.
Your Honor, may we publish Exhibit 1 for the jury?
You may.
Ms. Donaldson, were you able to spend a lot of time with your father?
Yes, I saw him almost daily for 20 years as I worked as his assistant at Wild Wild Life.
What kind of work did you do with your father?
I did everything from answering phones to scheduling meetings, writing checks. I ran the books, and my dad would often joke that I knew more about the business than he did.
Do you miss your father?
Yes, I miss him every single day.
At the time your father was last seen, was he married?
Yes, he was married to the defendant, Karen Beja.
Now I want to talk to you about your father's relationship with the defendant. Did you ever see the two of them together?
Yes, we all worked together for many years at Wild Wild Life.
Based on all those many years together and your own personal observations, how would you describe their relationship?
Not good.
Why would you say it wasn't good?
I heard them argue frequently.
When was the last time you heard them argue?
In the weeks leading up to just before my father went missing, I heard them arguing at the office.
What did you observe during that argument?
Well, I heard them arguing, and then Karen stormed out of the office, and then my father came out after.
How was your father's demeanor when he came out?
He was visibly shaken. I've never seen him like that before. And then he excitedly uttered to me, "If anything should ever happen to me, be sure to have the police look into Karen because she'll be the one responsible for my death."
Objection to hearsay.
Your response, Mr. Mays?
Your Honor, this falls under an exception to hearsay, excited utterance, 8032.
Response?
Yes, Your Honor. Just because this witness used the word excitedly uttered does not make this an excited utterance. Pursuant to Federal Rules of Evidence 8032, a statement relating to a startling event has to be made and it has to be related to that specific event. This statement is forward-looking. It's saying, if this was to happen, go to the police. So it's not related to any startling event or condition. No event is referenced in the statement, so it doesn't fall under 8032.
Mr. Mays, is there any other exception under 803 that you'd like to bring up to the court?
Yes, we also believe it is a state of mind 8033 exception, as we have a good faith belief that the defendant is arguing that that Karen Beja did not kill her husband. This goes to rebut that claim.
May I respond on those grounds, Your Honor?
You may.
Your Honor, note part of this statement is Lou Donaldson talking about his mental condition. He's not saying, "I'm so scared because," he's not saying, "I think that I'm in danger because." He is talking about what would happen in the future if he was missing. They're using this statement clearly for its truth value, that if he was to missing, that Karen Beja would be to blame. And that's exactly why it's inadmissible today, Your Honor. It's an out-of-court statement being offered explicitly for that truth value.
Mr. Trevisani, your objection is well noted for the record. However, I do think that this does go to show Mr. Donaldson's state of mind at the time under 8033. I will, however, be issuing a limiting instruction to the jury to remind them that they are the ones who are ultimately to determine who was responsible for Lou Donaldson's death, if anyone was responsible for Lou Donaldson's death. Thank you. Please proceed, Mr. May.
Ms. Donaldson, when was the last time you saw your father?
It would have been August 17th of 2012. It was around 6 p.m. on a Friday.
What happened when you saw him at 6 p.m.?
As he was leaving work, he invited me over for dinner that Sunday, and he said that if I didn't come, he would see me on Monday.
So that was a Friday. When was the next time you went to the Wild Wildlife?
That would have been on Sunday.
On a Sunday? Why'd you go on a Sunday?
Well, the alarm went off at around 6 a.m., so I went down there to go check and see if everything was okay.
What do you see when you got down there?
Well, I got there as the police were arriving, and I saw that the lock on the chain had been cut, and then the back gate had been completely broken into.
Besides the police, who else did you see there?
I saw the defendant carrying a locked box that was in my desk and another sketchy-looking man with lock cutters.
What was in that lockbox that was kept in your desk?
My father's will.
Your Honor, I have a photo which was pre-marked as Donaldson Deposition Exhibit 3. Ms. Donaldson, do you have a copy of Exhibit 3?
I do, yes.
Directing you to Exhibit 3, do you recognize it?
Yes, I do.
And what is Exhibit 3?
It's the back gate that was completely broken into.
Now, is this a fair and accurate depiction of that back gate, how it was on Sunday, August 19th, 2012?
Yes, it is.
Your Honor, at this time, we'd like to mark this as Plaintiff Exhibit 2 for identification, and we move into evidence.
For, just so I'm keeping track of things, is this a photo of the gate or of the lock?
This is of the gate.
Thank you. Mr. Trevisani,
No objection.
so entered.
May we publish Exhibit 2 for the jury, Your Honor?
You may indeed. Thank you for asking.
Ms. Donaldson, do you see your screen?
Yes, I do.
So is this the back entrance of the office?
Yes, this is the back entrance on the day of the break-in.
And your desk is in that office?
Yes, it is.
Thank you, Ms. John. So this was Sunday. When was the next time you went into work?
Monday, but the defendant fired me.
I want to go back and talk about that will in the lockbox. So that will that was kept in your desk, how did that split up your father's assets?
4 ways. So 25% went to my mom, 25% to me, 25% was going to go to a foundation to keep wild wildlife going, and then only 25% was going to the defendant.
At some point, did the defendant present a will?
Yes, 2 weeks after my father was last seen.
Was that will presented by the defendant the same as that will that was kept in your lockbox?
Absolutely not.
How are they different?
It left everything to her.
Your Honor, no further questions at this time.
Mr. Trevisani, do you have a cross-examination you'd like to give?
Yes, Your Honor. If I might just have one moment.
Of course, take your time. I'm going to step away from the bench for just 1 minute, and I'll be right back. Thank you. Figured I'd use that as an opportunity to refill my coffee. Mr. Trevisani, are you prepared to proceed with your cross-examination?
Yes, Your Honor.
All right, please proceed.
Good morning, Ms. Donaldson. Can you see and hear me okay on your screen?
Yes, I can.
Now, your father, he owned airplanes, right?
Yes, that's correct.
He also knew how to fly them.
Yes, he did.
He was a pilot, right, ma'am?
Yes.
And you know, as his daughter, that sometimes when he would fly, he would leave the country, right?
Yes, sometimes he would.
You know that sometimes your father, he would fly one of his planes over water, right, ma'am?
I would assume so, yes.
So let's talk about what happened on that date you mentioned on direct examination, August 17th of 2012. Now, ma'am, you remember that that was a Friday, right?
Yes, that was a Friday.
You saw your father at the office that night.
Yes, I did.
He left around 6 p.m.
Yes.
He didn't tell you where he was going, did he, ma'am?
No, he didn't.
But you are aware that your father, he owns a van, right?
Yes.
You didn't see where he drove that van when he left the office that day, right?
No, I didn't.
But ma'am, you do know that that van, well, it was later found, right?
Yes, I'm aware of that.
That van was found at an airstrip, right, Miss Donaldson?
Yes, that's where it was found.
That airstrip, it was just 40 miles away from the office that you saw your father leave that night, right?
Objection, Your Honor, outside scope of direct.
May I respond, Your Honor?
You don't need to, Mr. Trevisani. Mr. Mays, I'm going to overrule the objection. Cross-examination in this courtroom is going to be afforded some flexibility. So the objection is noted, but it's overruled. Thank you.
Now, Miss Donaldson, I want to piece together what happened at that airstrip. Now, your father, he actually owned multiple planes, right, ma'am?
Yes, he did.
He bought and sold planes all the time.
Yes, that's something he did.
He didn't always register those planes, though, right?
Sometimes he didn't.
Well, in fact, ma'am, you would say he never registered those planes.
I guess, yeah, that's correct.
Ma'am, is that a yes to my question? Your father never registered those planes?
I can't say that he never registered those planes. There were planes that were unregistered, though. Correct.
To be clear, ma'am, my apologies, Your Honor. To be clear, ma'am, in your own words, you would say he never registered them.
Correct.
Okay, so you're aware that pilots, well, they're supposed to log their flights before they take off from an airstrip, right?
I'm not aware of what all pilots do.
Well, ma'am, you know that folks, they're supposed to log their flights, right? Pilots are supposed to log their flights.
Objection lacks foundation.
May I respond, Your Honor?
Overruled.
Ma'am, you know that your father, he didn't always log those flights.
That is correct.
So let's put that all together. Your father bought and sold planes all the time. You don't actually know how many planes your father had, right, ma'am?
Correct.
You can't tell us if one of your father's planes is missing.
No, I can't.
Ms. Donaldson, you can't tell us if one of your father's planes is in the Gulf of Mexico right now.
No, I can't. But my father would always tell me when he was going out of town, and he never said anything that he was leaving.
Well, sometimes you learned about your father's trips after the fact, right?
That is correct. But he always told me when he was going out of town, and he made no mention that he was ever leaving. He always told me about his flights.
And if he ever went to Costa Rica, ma'am, you'd agree with me, you would learn about that from your father. You would talk to him about his trip, right?
Yes, he would always tell me where he was going out of town.
Mr.
So
Trevisani, I'm just going to interrupt for a moment. It looks like your camera has become unfocused. If we can, I'm not sure if you're able to adjust it.
I might be able to, Your Honor, if I move around. Thank you for letting me know. I appreciate that.
Yeah, that's okay. I just want to make sure that everyone who might be watching the trial or otherwise participating is able to see you correctly, including the witness.
Your Honor, I'm unable to see my screen perfectly well. Am I still blurry?
You are.
Okay, let me see if I
This
can.
is one of those hiccups we're all gonna be flexible with. So appreciate everyone just while he sorts through the problem.
I appreciate it, Your Honor. It wouldn't be one of my trials if I didn't have some sort of technical mishap.
That's okay.
Am I still blurry, Your Honor?
You are.
Okay, let me see.
Perhaps you can shut the video off, turn it back on. Just give that a go.
Probably a good idea, Your Honor. Thank you.
There we go. Turn it on, turn it off, and turn it back on. It always works. It always,
Works every time.
that's right. Go ahead, Mr. Trevisani.
My apologies, Miss Donaldson. Can you see me clearly now?
Yes, I can.
Okay, so I want to talk about that flight plan that you mentioned. So, as you told us a moment ago, your father, he would not always log his flight plans beforehand, right?
Correct.
In other words, ma'am, sometimes your father, he would take off from an airstrip without letting anyone know at that airstrip, right?
I can't say whether or not he let anyone know at that airstrip.
Well, you know that sometimes he would never log those flights with the airstrip, right?
Correct.
All right, ma'am. So when he took off from the airstrip on those occasions, no one at the airstrip could look at a flight plan to see where your father was going, right?
I suppose so.
Now, to your knowledge, before August of 2012, your father had never had a plane crash before.
No, he didn't.
But to your knowledge, ma'am, before August of 2012, your father had never flown without his glasses, right?
To my knowledge, like, I can't.
My apologies. Your Honor, was there an objection? I'm sorry.
Your Honor, objection, speculation, lacks foundation.
Your response, Mr. Trevisani?
Your Honor, I'm just asking about this witness's personal knowledge. To her knowledge, if he was able to fly without her glasses, and we believe this witness does know that her father needed those glasses to do most activities. We believe she has the knowledge to testify to this. And opposing counsel laid the foundation to their close relationship, how she would know this. So the requisite foundation has been laid for the witness to answer this question.
The objection is overruled. Thank you, Mr. Mays.
Ms. Donaldson, to the best of your knowledge, your father, before August of 2012, had never flown without his glasses, right?
To my knowledge, that's correct.
So now let's talk about your claim against Miss Beja today. Now, on August 17th of 2012, the night your father went missing, you didn't see Miss Beja shoot your father, did you?
No, I didn't.
That night, you didn't see Miss Beja disposing of a body, right, ma'am?
No, I didn't see that, but that doesn't mean that she didn't kill him.
That night, ma'am, in fact, that entire weekend, you never saw Miss Beja and your father together at all, right?
Correct.
So let's talk about some claims that you made on direct examination. Now, you told the members of the jury a moment ago that Miss Beja broke in to the office at Wild Wildlife, right?
Sorry, counsel, you kind of cut out when your screen went blurry. I missed the middle part of your question.
My apologies, Ms. Donaldson, and thank you for letting me know. You claimed on direct examination that Miss Beja broke into the office at Wild Wildlife, right?
Yes, she did.
You told the members of the jury that she was there and she stole a lockbox, right?
Yes, she did. She took that from my desk.
On direct examination, you talked about the broken lock and the broken gate, right, ma'am?
Yes.
Your Honor, may we republish the plaintiff's exhibits, I believe it's 3 and 4 on screen?
Which exhibits are these specifically?
Yes, Your Honor. It's the exhibit of the photos of the broken lock and the broken gate that were admitted into evidence on the direct examination.
To my recollection, only the photo of the gate was admitted during direct examination. Is that correct, Mr. Mays?
Yes, Your Honor, and that was plaintiff's exhibit 2, the gate.
That's my recollection as well.
Yes, Your Honor. In that case, we'll just show the photo of that gate, Your Honor.
That's fine. Go on ahead.
Ms. Donaldson, can you see that photo on your screen?
Yes, I can.
You'd agree with me, Miss Beja isn't in this photo of this broken gate, right?
No, she's not, but she was found with another man with lock cutters and carrying the lockbox that was in my desk.
When you say she was found, ma'am, you don't have any photos of Miss Beja breaking into the office, right?
No, I don't have any photos.
You don't have any security footage of Miss Beja leaving with a lockbox, right?
No, but like I said when we arrived, myself and the police, she was carrying a lockbox that contained my father's will.
Now, you said the alarm went off. That's why you and the police went there that morning, right?
Yes.
Ma'am, did you bring a record from the alarm company that shows that an alarm went off that day?
No, I don't have a record.
You said that the police were there. There were multiple policemen present, right, Miss Donaldson?
Correct. The police were there.
How many police reports did you bring to court today about this incident?
I don't have any police reports, counsel.
So then let's talk about why you brought this lawsuit. Now, when your father disappeared, his estate was worth about $5 million.
That is correct.
When your father disappeared, before that time, you thought that you were in his will.
I was in his will.
You thought that you were in line to inherit a quarter of his estate. Do I have that right, ma'am?
Yes, I was in there.
Miss Beja, well, she produced a will that left everything to her.
That is correct.
To date, ma'am, you haven't received a penny of your father's fortune.
That is correct.
You'd like that money, wouldn't you, Miss Donaldson?
Yes, she forged the will. She presented a fake will.
That wasn't my question. You'd like that money, right, ma'am?
Yes, because it does not belong to her.
Thank you, Miss Donaldson. Your Honor, we have no further questions.
Thank you, Mr. Trevisani. Mr. Mays, do you have any brief redirect that you would like to conduct?
No, Your Honor, no redirect. May this witness please be excused?
I'm sorry, what was that last bit there?
May this witness please be excused? No redirect.
Yes, Mr. Trevisani, is it okay if we let this witness go?
Yes, Your Honor.
All right. Ms. Donaldson, thank you for your time today. You can be excused. Does the plaintiff have any other witnesses that it would like to call?
Yes, Your Honor, but prior to calling our next witness, we would like to read in a portion of a deposition from an unavailable witness, Carl Bannister, who is the defendant's brother in this case.
Mr. Trevisani or any other representative from the defense, do you have any objection to this?
Your Honor, we would just ask that opposing counsel let us know which lines and which statements will be elicited so we can see if we have any objections.
Okay, I think that's appropriate. Ms. John, how will this be conducted? Will it be you and your co-counsel reading a question and answer?
Yes, Your Honor, my co-counsel and I will be reading in question and answer format. We can cite to the page numbers right now, and we also have a highlighted copy of the portions we would like to read that we can share with the screen if that is easier too.
I would like to, actually, that sounds great. If you can share that highlighted portion, I think that would make things smoother for everyone. And then you can see, oh, go ahead.
Oh, sorry. Maybe approach just so that way it doesn't prejudice the jury while we show you the portions we would like to read in.
Yeah, and we'll just say that that's constructively occurring. Let's pretend as if you've given us copies or that the deposition can only be seen by the court and by opposing counsel. And then you can proceed with your question and answer portion.
Yes. Mr. Mays, can you please share the highlighted copy? So it is these three questions, Your Honor, beginning on page 34 of the PDF record, as well as page 35, the second and third question and answer set.
Okay, you may proceed. If there are any objections, I expect that Mr. Trevisani will make those contemporaneously. Also, Mr. Trevisani, if there are other portions of this deposition that you would like read into the record after Ms. John is done, you may do so.
Your Honor, prior to reading this, would you like to instruct the jury at a later point in the trial what an unavailable witness is, or would you like me to do that now?
You don't need to do that. Let's say that I constructively instructed them before the reading of these questions and answers as to what an unavailable witness is and what a deposition is and so on. Thank you for the question. That's a good question.
Mr. Mays, may you please join us on the screen so we can read in question and answer format? Beginning with page 34 of the electronic record. Question: did you drive her back to her home?
I first took a look at her car and it would not start. So I made sure it was safe by the side of the road and then took her home. We got to her house around 3:45, definitely before 4 a.m.
Starting on page 35, second question. Are you aware that the Pioneer Sheriff's County Office keeps tracking records for all vehicles?
Sure, it is a good way to know where each deputy is located in the jurisdiction during a shift.
Are you also aware that there is no record of your patrol vehicle moving from 3:20 a.m. until nearly 6:30 a.m., as it was showing it was near the grocery store close to Ms. Baggio's home during that time?
Yeah, I looked back at that in preparation for this deposition, and the records show that my transponder, the device that gives the location of the patrol car, was malfunctioning, cutting in and out. The issue is noted in a maintenance log, and it was replaced the next day.
Your Honor, this concludes our reading of Carl Bannister's deposition.
Thank you, Ms. John and Mr. Mays. Mr. Travisani, are there any other portions of this deposition that you would like read into the record at this time?
Yes, Your Honor, we would.
All right, and just go ahead and make sure that Ms. John is aware of which portions you will be reading in.
Sure.
And then you can proceed with your question and answer with Mr. Ayers.
Your Honor, would
Oh, sorry, same time.
I was going to ask if opposing counsel, Your Honor, would also like us to put it up on screen. I can do that.
Ms. John?
Yes, or just a page reference as to where the testimony would be coming from would be appreciated.
Yes.
As well as for, as well as for
apologies.
clarification for the court, we ask that this reading of their portion of Carl Bannister's deposition be counted towards their case in chief.
It will be.
Your Honor, for the court's convenience, would you like me to share this portion on my screen?
If it's easy enough for you, that would be great. But if it's a hassle, it's not a big deal.
Yes, Your Honor, I have it here. We're going to be starting on page 33 of the deposition. Question: how are you involved in this case?
Mr. Ayers, you're muted.
Thank you. Well, I'm not involved in the case, but I guess you can say I am here because my sister is Karen Beja.
Are you older or younger than your sister?
She's my little sister, as I'm older by a couple of years.
Do you have a close relationship with your sister?
We're family, so there are ups and downs to any family relationship. However, I would say that we're pretty close.
Okay, let me ask you about that night. Well, early morning hours of August 18th, 2012. Do you remember that pre-dawn time?
Yes, I do.
How do you remember it?
I was on duty that night, graveyard shift, so from 12 a.m. to 8 a.m.
Do you remember about that time?
Well, it was normal sort of shift. I was just answering patrol calls when I got a personal call from Karen.
When was that?
It was close to 3 a.m. She had gone out to the grocery store late at night in order to get some milk or something for some newborn tiger cubs. She had car trouble and needed a ride home as soon as possible to get back to the cubs.
Did you go pick her up?
Yes, I did.
And Your Honor, that concludes the portion of the deposition we'll be reading onto the record.
Thank you, Mr. Travisani and Mr. Ayers. Is it Ayers or Ayers? I apologize.
Ayers, Your Honor, but it's no problem.
Ayers. Okay. I'm going to do my best to remember that. I'm not going to make any promises. Ayers. All right. Thank you both. Ms. John, does the plaintiff have any other witnesses it would like to call?
Yes, Your Honor, but prior to calling our next witness, we also would like to play a video for the jury. May this video be marked as Plaintiff Exhibit 4 for identification, or Exhibit 3, sorry. And this video is of someone named Exotic Bob, who both parties have stipulated is an unavailable witness for this trial.
Mr. Trevisani or Mr. Ayers?
Your Honor, we actually do object to this video being shown to the members of the jury. If I may be heard further.
You may.
Your Honor, while the parties did agree that this witness is considered unavailable, opposing counsel has yet to lay foundation to show that this testimony would fall under the exceptions under 804D. Just because he's unavailable, that's merely one precondition for the exception under Rule 804. And simply saying that he's unavailable does not make his statements, which we believe to be baseless rumors, to be admissible. So the video itself is hearsay.
Ms. John?
Yes, Your Honor. Pursuant to Federal Rule of Evidence 804B3, this falls under an exception as this is a statement against self-interest or against interest contained. And in regards to supported and corroborating circumstances, the defendant herself will be able to testify that she is aware of Exotic Bob, as well as aware of this video specifically and what he mentions. Any issues in regards to credibility goes to the weight and not the admissibility of this testimony.
May I respond, Your Honor?
Very briefly.
Your Honor, opposing counsel stated this falls under the statement against interest, but in the statements made by Exotic Bob, he doesn't say anything about, he doesn't make any statements that would put himself at, expose himself to any civil or criminal liability. All of his statements are about alleged conversations that he had with Miss Beja. Furthermore, Your Honor, pursuant to subsection B of that same rule, it has to be there has to be corroborating circumstances that support and clearly indicate its trustworthiness. And Your Honor, here, this is just a video that was shared online from the inside of a prison cell, and there's nothing that is going to corroborate it. So we don't believe that it's a statement against interest.
Right. Ms. John, I'll let you have the last word. Mr. Trevisani, make sure that you're muting when you're not speaking, please.
Yes, Your Honor.
Thank you.
Yes, Your Honor. A transcript which has been recorded with the court can be found in the electronic version, page 30. And this is a statement covered by the statement against interest exception. And that specifically, he talks about an illegal deal that he did with the defendant in this case. And the additional statements from the defendant are not hearsay, as they are an opposing party admission.
Thank you, Ms. John. With that proffer, I'm going to allow this video to be played, and you can go ahead and publish that as it is now entered as Plaintiff's Exhibit 3. Thank you.
Thank you, Your Honor. Mr. Mays, can you please share that video with the jury?
Hey there, cat sister, where you put your mister? Feed a little lion's den. Hey there, cat sister, where you put your mister? Feed a little lion's den. Hey there, I'm Exotic Bob. You probably recognize me as the owner of the world-famous leopard camp, I See Spots. I want to thank you for your patronage over all these years. I'm currently a guest of the federal maximum security hotel system. Compliments of one Karen Baja, and that's who I'm here to talk to you about today. You see, it was 2 years, 2 weeks, and 2 days to the day that her husband was last seen alive. She and I was working on a highly illegal deal. We was illegally importing leopards and lions. Leopards was for her, leopards was for me, lions was for her. Now, we never worked together before, and we never worked together since. But due to the severe illegality of the deal, we thought it best to be work together, so we did. And at the end of that meeting, Karen Baja walking out of my office, she stopped suddenly, turned around, and she came marching back to my desk, and she leaned over and she looked me right in the eye and she said, "Exotic Bob," that's me, Exotic Bob. She said, "Exotic Bob, I swear if you double cross me on this deal, I will do to you exactly as I did to my husband." She said, "There won't be no disappearance, no mythical flight to Costa Rica." She goes, "Your last supper will be you. I'll feed you to my kiddies just like I did him." And then she turned around, she walked out of my office. That's all I've got to say about that. Hey there, evil woman, where you think you're going? We all know where you've been. Hey there, evil woman, where you think you're going? We all know where you've been.
Your Honor, with that, the plaintiffs call our next witness, Taylor Pride, to the stand.
All right. And who will be cross-examining and handling objections for this particular witness?
I will, Your Honor.
All right. Thank you. Mr. Pride, good morning.
Good morning.
Would you please raise your right hand? Do you tell the truth?
Yes.
Thank you. Please proceed, Ms. John.
Good morning. Please introduce yourself to the jury and tell us what you do for a living.
Good morning. My name is Taylor Pride. I'm a forensic document examiner and private investigator. I actually run my own shop, Pride Investigations.
What do you do as a forensics document examiner?
Well, a forensic document examiner runs forensic analysis on documents, things like comparing handwriting to detect if there's any fraudulent activity, forgeries, things like that.
You also mentioned that you own your own shop, Pride Investigations. When did you first open it?
I first started that company in 2016. That was just after I left my time at the police department.
Let's actually talk for a little bit about your time at the police department. Were you an officer?
Yes, I joined the force in '98. And after that, I quickly was promoted to detective, and that's where I served for the rest of my time until 2016.
How long were you a detective?
16 years.
And what were your duties as a detective?
Well, I, ran investigations. I gathered evidence on any number of crimes, everything from sort of financial white-collar crimes to the, more darker homicide and murder cases.
Did you investigate any forgeries?
Yes, I did. For a few years, I was actually assigned to the economic crime unit. And so I spent a lot of time doing fraud investigations, forgery investigations, things like that.
And sorry to interrupt. Can I inquire with the court whether Mr. Pride's screen is frozen on their end as well, or is it just mine?
It looks to me like maybe a little bit of a spotty connection. It's kind of coming in and out. However, the audio is very clear. So if we can just proceed with the questioning, as long as Mr. Ayers is okay with it. You're not having any issues on your end, I'm assuming, Mr. Ayers?
No, Your Honor. I have the same issues it sounds like the court does. The witness keeps freezing, but I can hear him perfectly well.
Okay. For these purposes, let's just go ahead and continue with the questioning since we have clear audio. Thank you.
Mr. Pride, are you certified in forensics document examination at all?
Yes, so I am certified with the Board of Forensic Document Examiners. That's a sort of governing body that has a certification process.
Have you ever testified as an expert in court before?
I have. I've testified on 15 occasions.
Your Honor, at this time, plaintiffs tender Mr. Pride as an expert in handwriting analysis and investigation.
Mr. Ayers?
I have no objection as to this witness being qualified as an expert in handwriting identification, but investigations is too broad of a field. I don't believe that opposing counsel has laid the foundation that this witness can be qualified as an expert in investigations in their totality, nor could he offer an expert conclusion as to investigations.
Ms. John?
Your Honor, this witness has testified that he has not only spent 16 years with the police department as a detective, plus an additional 2 years as an officer. Also throughout that time, he testified that he's investigated everything from economic crimes to murders and everything in between. So he's more than qualified to testify to an investigation and his expertise.
I agree, Ms. John. I'm going to allow the tender. Mr. Ayers, if you want, do you want to conduct any kind of voir dire or questioning about that before we allow the tender?
Not at the moment, Your Honor, but based on
Okay.
what this witness comes to conclusions about, I may have cross-examination questions.
Okay, very well. And that's fair game. So Ms. John, you may proceed, and the witness is now tendered as an expert in criminal investigation. And I'm sorry, the second or first tender, rather, was that in forensic, what was that?
It was in handwriting analysis and investigations, Your Honor.
Handwriting analysis, okay. Those are the tenders as the court has ordered. Please proceed.
Turning your attention to today's case, how'd you get involved?
Well, in July of 2017, I was hired by Cam Donaldson to investigate two things: her father's disappearance, as well as there was a last will and testament that was presented as belonging to her father, Lou Donaldson. I was asked to look into the authenticity of that document.
How did you investigate Mr. Donaldson's disappearance?
Well, I pulled a lot of his personal bank financial records. I looked at various documents. I compared the last will and testament to other records of his handwriting that we had. I also looked at people in and around his life, specifically Miss Karen Bezia.
Why did you specifically look into the defendant?
Well, it was my understanding that there was a pretty significant financial motive here. We have a $5 million life insurance policy, as well as a $5 million estate that's at issue, all of which going to Ms. Bezia. That certainly raises questions.
Mr. Pride, after conducting your investigation, did you reach an opinion in this case?
I did.
Do you hold that opinion to a reasonable degree of professional certainty?
I do.
What is your opinion?
Well, it's my opinion, my conclusion that the last will and testament that's at issue in this case is fraudulent. It's also my opinion that Ms. Bezia was involved in her husband's death.
You mentioned earlier that you looked into some bank records. Whose were those?
Yes, I pulled all of Mr. Donaldson's financial records, specifically his bank statements leading up to his disappearance.
Your Honor, I have a document. May it be marked as Plaintiff Exhibit 4 for identification. This document appears to be a bank statement. Mr. Pride, do you have a copy of the exhibits in front of you?
Yes, I do.
Directing you to Plaintiff's Exhibit 4, do you recognize it?
I do recognize this document, yes.
What is it?
These are those bank records I was mentioning just a moment ago, the ones that I looked at in my investigation.
Is Exhibit 4 in substantially the same condition as it was when you last reviewed it?
These appear to be in the same condition as when I reviewed them.
Your Honor, plaintiffs move Exhibit 4 into evidence.
Mr. Ayers?
No objection.
So entered. Plaintiff Exhibit 4 is the bank statement.
Permission for my co-counsel to publish for the jury.
Permission granted.
Mr. Pride, why was Lou Donaldson's bank statement important to your analysis?
Well, one of the things that I noted was that there was a significant $3,000 cash deposit just a few days before his disappearance. Additionally, as we can see in these documents, he doesn't use his bank at all after his disappearance. There's no money in or money out. There's no charges made, especially no charges in Costa Rica. And this all implied to me that Mr. Donaldson was probably deceased.
Thank you, Mr. Mays. You can take that down. Let's shift gears a little bit. You mentioned that you analyzed Mr. Donaldson's last will and testament, or the document the defendant presented as that. What did you review in your analysis of that document's authenticity?
Well, I looked both at the language of the document as well as the circumstances surrounding it. I spoke with one of the witnesses who had signed. I also compared the signature that was on that document.
Your Honor, I have two documents. May the first be marked as Plaintiff Exhibit 5, which appears to be the document the defendant presented in this case as the alleged will. And may the second be marked as Plaintiff Exhibit 6, which is a request for a restraining order that's been filed with the court. Mr. Pride, do you have the exhibits in front of you?
I do. I'm looking at them right now.
And do you recognize them both?
I do. One of these documents is the last will and testament that was analyzed by me. Another one is a temporary restraining order that was filed with the court system, which I pulled and I used because it bore Mr. Donaldson's signature. And we knew
Objection, Your Honor. Under Rule 403, may I be heard?
Yes, you may.
The witness has just misdescribed what that second document was. This is not a temporary restraining order. It is a request for a temporary restraining order, which was denied. For this witness to call it a temporary restraining order on the stand today is unduly prejudicial and may confuse the jury as to what actually happened in this case.
I'm not going to hear any response to that. I agree, Mr. Ayers. I need this. If we're even going to be proceeding, allowing the jury to hear any testimony about a request for a restraining order or anything like that, we need to make sure that we're all calling it by exactly what it was, which is a request for a restraining order, a temporary restraining order, not a restraining order. Mr. Ayers, does your objection extend from there?
Yes, Your Honor. We'd object to any testimony about this request for a restraining order whatsoever.
Okay. Ms. John, your response.
Yes, Your Honor. Pursuant to Federal Rule of Evidence 403, we believe the probative value of this testimony, and specifically this document, it's a request for a restraining order where Lou Donaldson said the defendant threatened him, that he was seeking a divorce, and that he did not feel safe around the defendant. That was filed with this district court just 2 days before he allegedly signed the document in question. The probative value of this testimony substantially outweighs any prejudicial effect in that it gives us an insight into the state of mind of Mr. Donaldson just 48 hours before he allegedly signed the document in question.
Mr. Ayers?
First off, Your Honor, I assume we're constructively outside the presence of the jury here.
Good point. Yes, we are.
Would it be helpful for my co-counsel to display the document on screen so we can all see the same document as we talk about it?
That's not necessary right now.
Under Rule 403, this is substantially more prejudicial than it is probative. The probative value here is very, very thin. A court has already looked at this request for a restraining order and determined the information contained therein to be either insufficient or not trustworthy. Accordingly, they denied this request for a temporary restraining order. The prejudicial value, on the other hand, Your Honor, is incredibly high. A jury might see this and believe that all the statements contained therein are believable, are trustworthy, are sufficient, despite the fact that there is no opportunity for us to examine either on direct or on cross Lou Donaldson. Secondly, Your Honor, if you determine that this does meet the 403 requirements, we have a separate objection to hearsay as to one of the statements contained within that document.
Okay, Mr. Ayers and Ms. John, having heard the argument from both sides, I think that we may be missing something here. As the ruling judge, I don't want to get appealed. I think that this is bad propensity evidence under 404. So with that in mind, I'm going to preclude the admission of the temporary restraining order, except for the purpose, and I believe this is what you are offering it for, Ms. John, of, or at least partly, of signature comparison. So the request for a temporary restraining order can be admitted, except it will be entirely redacted other than the signature and the date of the signature. Is that clear to everybody?
Your Honor, may I be heard on that?
You may.
In regards to the propensity argument, we have no intention of arguing this document or the claims contained therein that it is indicative of the defendant's behavior on a specific day or that she acted in accordance. However, the claims within that document are necessary for the jury to fully assess Lou Donaldson's state of mind at the time. Specifically, that this document was signed 48 hours before the alleged will in question calls into question the credibility of the document the defendant has presented today, in that if Lou Donaldson was seeking a divorce, felt threatened by the defendant and unsafe around her, it's unlikely that he would have signed everything in his estate over to her just 48 hours. We're not offering it to show she acted in conformity with these claims, but specifically to show Lou Donaldson's state of mind around that time.
Your objection is noted for the record. or your argument is noted for the record and for any possible appeal. But at this point, I've made my ruling. I'm going to be precluding the contents of the request for a temporary restraining order, except for the signature and date of signature. And if you want to admit that, we can just constructively redact the rest of it.
Yes, Your Honor.
Sorry, Mr.
I was asking if I could clarify one point, Your Honor.
You may.
I understand that the request for a temporary restraining order itself won't be allowed in. Any testimony relating to the existence of that temporary restraining order request, is that also non-admissible?
Correct. And any prior testimony will be stricken from the record, and I will instruct the jury to disregard it. Thank you.
Thank you, Your Honor.
And Your Honor, with that instruction, may plaintiffs exhibit 5 and 6 be admitted into evidence, assuming the restraining order is constructed?
Yes.
And permission for my co-counsel to publish both exhibits 5 and 6 for the jury?
That's no problem at all. Go on ahead.
Mr. Pride, you mentioned that you spoke to one of the witnesses for this document that the defendant presented. Who did you speak to?
Specifically, the will document. Yes, I spoke with Miss Samantha Lane.
And what did she say?
Objection, Your Honor. Question calls for hearsay.
Your response, Ms. John?
Your Honor, experts are allowed to rely on hearsay pursuant to Federal Rule of Evidence 703.
Overruled.
Mr. Pride, what did Samantha Lane say when you spoke to her?
Well, when I spoke with Miss Lane, she told me that she, in fact, had never seen Mr. Donaldson sign this document, and that she was, in fact, threatened by Miss Beja to testify as such, to say as such in this document.
Did she tell you why she signed as a witness if she never saw Mr. Donaldson sign this document?
She, as I mentioned, she told me that she was threatened by Miss Beja.
You also mentioned, what threat did she say specifically?
She specifically said that there was a threat to her life.
To her life? Is it that she would feed her to the cats? Did that sound about right?
Yes.
Objection, Your Honor. Leading.
I think that was a sort of form of refreshing.
Yes, Your Honor.
Please be careful there, Ms. John.
Yes, Your Honor.
Sorry.
Oh, no apologies necessary, Mr. Pride. You also mentioned that you reviewed the contents of this document. What specifically in the language did you review?
Well, as you can see in the language there, it uses the phrase "if I die or disappear." Now, in my experience, I've reviewed many wills. I've spent a lot of time checking for forgery, and I've never seen that particular phrase used ever before.
You also mentioned that you analyzed the signature on Mr. Donaldson's alleged will. How did you do that?
Well, I pulled the signature off of the will and compared it to the one that was on the request that had been filed with the court, as well as his driver's license record as well, and compared a lot of very specific details about the various signatures to make a conclusion about its authenticity.
And looking at these two documents here, what is the time difference between them?
Well, there was a 48-hour difference, just a couple of days after this was recorded with the court, that this last will and testament was filled out.
And Mr. Mays, you can go ahead and take down the restraining order and just publish for the jury a copy of the document on the right, the alleged will in question.
Objection, Your Honor, as to any testimony or statement by opposing counsel about any restraining order whatsoever.
That's going to be sustained. So I'm just going to instruct all parties at this point, and we're outside the presence of the jury right now, rather than referring to it as a restraining order or a request for a restraining order or anything like that. Find a different name for it. I would suggest that an appropriate name might be signature comparison document 1 or something along those lines. However you want to refer to it, just no talk about a restraining order, okay?
Yes, Your Honor.
Yes, Your Honor, as a point of clarity, we will be referring to it as a court document from here on out.
That's fine.
Permission for my co-counsel to publish solely Plaintiff Exhibit 5.
Granted.
Mr. Pride, when you were analyzing the signature on this document, what was significant to you?
Well, looking at this signature, especially in comparison to others, there were several things that stood out. First, to the trained eye, it appears that this signature, the pen that was used to write it was lifted several times. It appears that each of the letters was written in a very specific individual way. And also there are some quiver marks, some hesitation marks that we see. So all of those were red flags for me.
Mr. Mays, can you zoom in a little bit more? You mentioned that there were the pen lifted. What did you mean by that?
Well, certainly. So in the other handwriting documents I used in my analysis, it appears that when Mr. Donaldson signs, he signs very fluidly, as if he's only using, the pen only touches the surface of the paper once and then lifts. Here we can see some spaces where it appears that the pen was taken off in between the two names. And so that sort of indicated to me that this might be someone different writing this.
What did the author signing every letter indicate to you?
Yeah, so in the other signatures that we know belong to Mr. Donaldson, there are a few letters that kind of get skipped over. We refer to them as sort of lazy letters, right? So specifically that O in his last name, that last O, would typically be sort of run through very quickly. It wouldn't even be presented. Whereas here, each and every letter seems like it was clearly written out. And that was a difference. And that also implied to me that this might have been signed by someone else.
What did the quivering lines indicate to you on this signature?
Well, these quivering lines sort of indicate that, this person wasn't writing quickly and fluidly. They were taking their time, maybe even comparing to another signature to look at. These are, red flag signs that this might be a forgery.
You can remove the exhibit, Mr. Mays. After reviewing this document for its authenticity, did you reach a conclusion regarding the validity of this document?
Yes, based on everything I've been testifying to today on my investigation, it was my conclusion that this was a forged signature, that this will was illegitimate.
Thank you, Mr. Pride. No further questions, Your Honor.
Thank you. Mr. Ayers, will you be conducting any cross-examination?
Excuse me, Your Honor, I will.
All right, please go on ahead and do that.
Good morning.
Good morning.
Can you see and hear me okay?
I can, yes. Can you see and hear me? I know it seems my internet's been sort of pausing, so if at any point I lose connection, just let me know or I'll try to fix it as quickly as possible.
Thank you. I can see and hear you perfectly fine. Let me ask you this. You're a private investigator, right?
That's right.
You were hired by the plaintiff, Cam Donaldson.
Yes.
You were hired to look into Lou Donaldson's disappearance.
I was.
You're a former police detective, right?
That's correct.
You worked for the police department for 16 years, was it?
That's how long I was a detective, yes.
So with your 16 years of experience as a detective, you're familiar collecting and analyzing evidence, right?
I am.
Evidence that can include eyewitness evidence?
Yes.
It can include physical evidence.
Absolutely.
Let's talk about the eyewitness evidence in this case. How many witnesses did you find who saw Karen Beja kill her husband?
To my knowledge, there are no witnesses that observed that event happening.
How many witnesses did you find who saw Karen Beja disposing of her husband's body?
The same answer. There was no one who I'm aware of who was standing by watching that happen.
Not asking who was standing by watching. I'm asking how many you found. The answer's 0, right?
That's right.
In fact, you didn't find a single eyewitness who even saw Karen Beja with her husband the weekend he disappeared.
That is right.
So let's talk about the physical evidence. You didn't find blood at Karen Beja's home, did you?
No,
You didn't talk to anyone who found blood at Karen Beja's home?
that's right.
What about skin?
No skin was found anywhere, if that's what you're asking about.
Right. There was no DNA evidence whatsoever that connected Karen Beja to her husband's disappearance.
No DNA evidence.
And no fingerprints.
No fingerprints.
Now, as a former detective, you're familiar with the term crime scene, right?
Of course.
I'm sorry, you might have cut out. Was that a yes?
Yes.
A crime scene, that's the place where a crime is committed.
Generally speaking, yeah.
You can't point to a particular crime scene in this case, though, can you?
No, not a specific location.
You can't point to a vague location, can you?
No.
You can't actually tell us where this supposed crime occurred.
No.
As a former detective, you're also familiar with the word murder weapon?
Yes, I am.
That's the object used to kill a person.
Objection argumentative as to counsel's hand motion.
Overruled. Although, Mr. Ayers, I'll suggest that you restrain sort of suggestive hand movements, that sort of thing.
Of course, Your Honor.
Your questions.
So, Mr. Pride, a murder weapon is the object used to kill a person, right?
That's right.
But you can't point to a particular murder weapon in this case.
No, I cannot.
You can't tell us how Lou Donaldson was supposedly killed.
No.
Lou Donaldson was declared dead in 2017, right?
Yes, I believe he was legally declared dead then.
That's right, he was legally declared dead because he wasn't actually found dead, was he?
No body was recovered.
Right, you didn't find the body.
No.
As far as you know, in the last 8 years, well, no one's found the body.
To my knowledge, in the last 8 years, there's been no trace of him.
In the course of your investigation, you found that Miss Beja, she's never been charged with the disappearance of Lou Donaldson, has she?
She's never been charged, to my knowledge.
As far as you know, no one's been charged in any crime to do with the disappearance of Lou Donaldson.
That's my understanding, that there hasn't been an official charge yet.
Or arrest, though, either, right?
Yes, same thing.
So let's talk about another possibility. You know that Lou Donaldson would sometimes fly to Costa Rica, right?
That is my understanding, that he was an aviator.
Right, he didn't fly commercial.
No, he owned his own planes.
He was a pilot.
That's right.
He both owned and flew his own planes.
Yes.
His van was found at an airstrip, isn't that right?
Yeah, that's my understanding, is his van was found with the keys inside.
Objection outside the scope of direct.
I'm going to allow some latitude, just generally speaking, in this trial on cross-examination. Objection noted, but overruled.
Mr. Pride, you said that the keys were found in the front seat, but it wasn't just his keys that were found in that van, was it?
No, his glasses were in the front seat as well.
That's right. In the front seat of the van found at the airstrip were Lou Donaldson's glasses?
Yes.
Now, as part of your investigation, you actually sent employees to Costa Rica to look for Lou Donaldson, right?
I did. I sent one of my employees to look in Costa Rica, see if they could find any trace of him.
They couldn't.
No.
But Mr. Pride, between here and Costa Rica, that's an awfully long way, isn't it?
Yeah, I can't remember the exact mileage off the top of my head, but something over 2,000 miles, if I'm not mistaken.
Does 2,200 miles sound correct? I'm sorry, you might have cut out. Was that a yes?
Your Honor, it appears that Mr. Pride is having connectivity issues. May we have a brief recess while he rejoins us?
Looks like he's slowly
Are you
coming
in?
back.
Sorry, can you all hear me?
We can
hear
hear
fine, Mr.
you,
Pride.
but you're paused, but we can hear you. Oh, now we cannot hear you, Mr. Pride. We're still not getting any sound.
Can you hear me now?
Yes?
Yes.
Yes,
For the
Mr.
time
Pride.
being.
All right. Unplugging and replugging in my Ethernet cable seems to have done something.
May I proceed, Your Honor?
You may. If there are more difficulties, we'll just roll with it and figure it out from there, okay?
Of course. Mr. Pride, the distance between here and Costa Rica, it's about 2,200 miles, right?
Yes, that's right. 2,200 sounds about right.
Now, you said you sent an investigator to Costa Rica, but you didn't send anyone to investigate that 2,200-mile stretch, did you?
No.
You didn't investigate the number of small plane crashes that occurred in that 2,200-mile stretch the weekend that Lou Donaldson disappeared?
That's right. I don't recall any. Yeah, that's right.
You didn't look up any unusual weather patterns that occurred in that 2,200-mile stretch the weekend Lou Donaldson disappeared?
No, I did not look at the weather patterns in that entire area.
You know that Lou Donaldson, he owned multiple planes, didn't he?
That's right. That's my understanding.
You don't actually know how many he owned.
I certainly don't. That's true.
So you can't tell us if one of Lou Donaldson's planes went missing the same day he did.
Objection calls for speculation.
Overruled.
Mr. Pride, I'll ask again. You can't tell us if one of Lou Donaldson's planes went missing the same weekend he did.
I think this might be a little bit more than just a pause. So we'll just hold tight until Mr. Pride can fix his connection there.
Thank you, Your Honor. Mr. Pride, can you hear us?
Can you all see and hear me?
Oh, we've got you.
We can hear you.
Please proceed.
Mr. Pride, you can't tell us if one of Lou Donaldson's planes went missing the same day he did.
That's correct. I am unaware if any of Mr. Donaldson's planes went missing the same day.
No further questions, Your Honor.
Thank you, Mr. Ayers. Any redirect, and if so, will it be brief?
No redirect, Your Honor. May this witness be excused.
Mr. Ayers?
This witness can be excused as far as I'm concerned, Your Honor.
All right. Mr. Pride, thank you for your time. At this time, you may be excused.
Your Honor, with that, the plaintiff rests.
All right. Mr. Ayers or Mr. Trevisani, do you have any motions to make at this time or anything that you'd like to bring to the court's attention?
Yes, Your Honor. We move for judgment as a matter of law under Rule 50 of the Federal Rules of Civil Procedure. Even viewed under the light most favorable to the non-moving party, no reasonable juror could find that the plaintiff has met their burden. They had to prove by a preponderance of the evidence that Ms. Beja killed her husband, and they provided no proof of this accusation. There's no direct evidence, no eyewitnesses. We realize that parties are allowed to prove their case with circumstantial evidence too, but the plaintiff didn't present that either. They presented no physical evidence, no blood, no hair, no skin, no DNA, no body, nothing. The only thing that their expert concluded was about the signature on a will, but this isn't a forgery or probate case. It's a wrongful death case. So we move for a judgment as a matter of law.
Mr. Mays?
Your Honor, we have provided significant circumstantial evidence to show that Miss Beja was involved in her husband's death. Specifically, we heard from Cam Donaldson, who told us that her father, in the weeks leading up to his when he was last seen, said that if anything should happen to me, to look into the defendant. Additionally, we heard from two other individuals who received threats from Karen Beja. We heard from Bob Exotic in his video, and we also heard from Miss Lane through Taylor Pride that, and Miss Lane is the only other witness to that will, that she was blackmailed and threatened by Karen Beja. And this, along with the clear motive for the defendant, is more than sufficient for a reasonable jury to conclude that Ms. Beja intentionally killed her husband. For those reasons, we respectfully ask the court to deny this motion.
Thank you to both parties. I will be denying the motion for judgment as a matter of law. I do think that there is enough evidence here when viewing that evidence in the light most favorable to the plaintiff that a reasonable juror could find in favor of the plaintiff. It's not my job to act as an extra juror in the case, so I think it's best that we leave it up to the jurors. With that in mind, are there any other motions or anything like that, Mr. Ayers?
None more from the defense, Your Honor.
All right. With that in mind, I would like to take a 10-minute recess to allow the defense to gather its witnesses and evidence and organize itself if it wishes to put on any evidence or case, and also to get some more coffee for myself. So with that in mind, I would like everyone back here at 10:55, please. Thank you very much. Hello, everyone. Are both parties prepared to proceed?
Plaintiff is ready, Your Honor.
Defense is ready, Your Honor.
All right, fantastic. And so we will proceed. Does the defense wish to present any evidence or witnesses?
Yes, Your Honor. The defense calls Karen Beja to the stand.
Okay. Good morning, Ms. Beja. Can you hear me okay?
Yes, Your Honor.
All right, fantastic. Would you please raise your right hand? Do you swear to tell the truth?
I do.
All right, fantastic. Mr. Travisani, you may proceed.
Yes, Your Honor. Good morning, ma'am. Can you see and hear me okay on your screen?
Yes, sir.
Please introduce yourself to the members of the jury.
Hello, my name is Karen Beja.
Where do you live?
I live here in Pioneer. I've lived here all my life.
When did you meet someone named Lou Donaldson?
20 years ago.
How did you and Lou meet?
Well, I was hitchhiking and he stopped. I figured he was just a nice guy, but I didn't know he was going to be my soulmate.
When did you and Lou get married?
2001.
I want to talk about your marriage for the members of the jury. What were some of the things that you and Lou liked to do together?
Well, we had a shared passion for animals, especially tigers. So we spent most of our time building and growing our animal sanctuary.
Would you describe the nature of your relationship to Lou Donaldson just generally, ma'am?
Yes, I loved him. Our marriage had its ups and downs. All marriages do, but I loved him with all my heart.
Miss Beja, did you kill your husband?
Absolutely not.
Did you dispose of your husband's body?
No.
What role did you play in Lou Donaldson's disappearance?
None whatsoever. I don't know what happened to Lou. All I can say is I had nothing to do with it.
So then let's talk about what might have happened. Ms. Beja, I want to ask you, how many airplanes, did your husband have?
Lou had several planes. I can't even tell you how many.
So when Lou would fly, do you know if he would ever take anyone with him?
No, Lou would fly solo.
When he would fly, ma'am, do you know some of the locations that he would frequent?
Yes, he would mostly fly to Central America, particularly Costa Rica.
So when your husband would fly to places like Central America and Costa Rica, how often would he tell you beforehand?
Almost never. I would only find out later that he'd landed or that he'd come home.
Ma'am, when was it that your husband disappeared?
That was August 17th, 2012. He drove to the office and I never saw him again.
I want to piece together what may have happened after you never saw him again. Do you have attachment 4 to your deposition available to you, ma'am?
Yes, I do.
Let me know when you have it in front of you on screen.
Yes, I have it open.
What is this photograph?
This is Lou's van. It was an '89 Dodge Ram.
Does this look to be the same version of the photo as the last time you saw it?
Yes.
Your Honor, at this time, we offer this photo as Defense Exhibit A.
Mr. Mays,
No objections, Your Honor.
so entered.
May we publish Exhibit A for the members of the jury on screen?
You may. Thank you for asking, Mr. Travisani.
Now, Ms. Beja, after your husband disappeared, when was the next time you saw this van?
August 25th, 2012, a week after Lou disappeared.
Where was it?
It was at an airstrip, about 40 miles from here.
I want to talk about what was inside that van. Ma'am, if you could open up attachment 5 to your deposition? Let us know when you have it on screen.
Yes, I have it here.
Do you recognize this photograph?
Yes, this is the inside of Lou's van. This is what it looked like when I saw it at the airstrip that day.
Does this photo look to be in the same condition as the last time that you saw it?
Absolutely.
Your Honor, at this time, we offer this photo as Defense Exhibit B.
Any objection, Mr. Mays?
No objections, Your Honor.
So entered.
May we publish on screen, Your Honor?
You may.
Ms. Beja, do you recognize those glasses?
Yes.
Mr. Ayers, if you could just zoom in just a bit. Ms. Beja, I want you to take a close look at these glasses and think carefully before you answer. Whose glasses are they?
These are absolutely Lou's glasses.
Thank you, Mr. Ayers. So, Ms. Beja, I want to talk about what you were doing that night. Where were you the night that your husband disappeared?
Well, first I was at home, and then I went to the grocery store.
When did you go to the grocery store?
3 a.m.
Ms. Beja, why were you going to the grocery store at 3 in the morning?
Well, I was taking care of some newborn tiger cubs at the time, and as anyone who's raised kids would know, that can sometimes mean some sleepless nights. So I had to go out and get some milk and formula for them.
I understand. Are there any people, or is there anyone who can verify where you were that night?
Yes, my brother. My car broke down, so I called him and he gave me a ride home.
Ms. Beja, did you see your husband at all that night?
No, earlier in the night, I didn't think much of it. I was in the nursery, so even if he had come home, I wouldn't have seen him. But when I got back from the grocery, Lou wasn't there.
Ms. Beja, have you been sitting where you are throughout today's trial?
Yes, sir.
I want to ask about some of the claims that have been made by the plaintiff today. Do you remember when we heard a video from someone named Exotic Bob?
Yes, I do.
Do you know this person?
Unfortunately.
In the video that was played in front of the members of the jury, this person claimed that you confessed to killing your husband. Ma'am, is that true?
Of course not.
We also heard testimony from Cam Donaldson. So I want to ask, ma'am, before your husband disappeared, did you ever threaten to kill him?
No, absolutely not.
Cam Donaldson also told us a story about you breaking into your father's office, stealing a lockbox. Is that true?
Of course not. I was a co-owner. Why would I need to break in?
Ms. Beja, were you ever questioned by the police after your husband disappeared?
Yes, they did question me, and they searched my home.
When you say they searched your home, what do you mean by that?
Well, I mean, they looked for physical evidence. They even tested our meat grinder, which we used to prepare food for the tigers.
So after the police searched your home and asked you questions, were you ever arrested?
No.
Were you ever charged with a crime, Ms. Beja?
No.
To the best of your knowledge, were you ever named a suspect?
No, they searched my house, and that was the end of it.
Thank you, Ms. Beja. Your Honor, we have no further questions at this time.
Any cross-examination, Mr. Mays?
Yes, Your Honor, but before I begin my question, maybe constructively approach based on a prior ruling.
Sure.
The plaintiff believes that the defense has opened the door to a line of questioning relating to the temporary restraining order. On direct, they testified that their marriage was normal, and the defendant also said that she had never threatened to kill Lou Donaldson, and the TRO's claims directly within it are we go to rebut these claims. So we're looking to bring in this evidence to rebut the idea of their normal marriage and also rebut the credibility of their will.
Mr. Trevisani?
Your Honor, we don't believe that we've opened any door to the request for the temporary restraining order. If opposing counsel wants to cross-examine Ms. Beja about the state of her marriage, about whether or not her statements regarding a death threat were true, he's welcome to do so. But allowing this TRO to come in would not rebut that. We don't believe that these statements are true. And so they're out-of-court statements that are being offered for their truth. And we don't believe we've opened the door that would allow your prior ruling to not apply now.
Mr. Mays, I'll allow you the final word.
Your Honor, the witness on direct clearly said she had never threatened to kill her husband. This evidence on that TRO completely rebuts that claim, and they've opened the door to us presenting that.
I'm inclined to agree, Mr. Mays. I'm going to limit any cross-examination about the TRO to that specific issue of a prior threat. I'm also going to, if you decide to go into that, issue a limiting instruction to the jury stating that the TRO isn't to be considered for any truth purpose, but rather only to go to Ms. Beja's credibility. Does that make sense?
Yes, Your Honor, just to clarify, there are 3 claims on that TRO: a threat to kill, the divorce, and not feel safe around them. Which, are we allowed to go into all 3 of those?
Just the threat to kill, because it rebuts a direct claim that Ms. Beja just made.
And would we be allowed to publish that to the jury?
The entire TRO?
We could constructively redact those 2 other portions, or I could ask my co-counsel to redact.
No, I'm not going to allow that, but if you want a question about it, you can, okay?
Okay.
Thank you.
I have a moment, Your Honor.
You may.
Sorry, Ms. Beja. When you met Lou Donaldson, he was already married?
Yes, he was.
He was 20 years older than you?
That's correct.
And that time you started a romantic affair with him.
Yes,
And soon after, he left his first wife
that is true.
and married you, correct?
Yes,
And then after 11, 12 years of marriage, he started seeing somebody new, correct?
yes, if you're referring to the mistress in Costa Rica, that is correct.
Right. And also at that time, Lou told you he wanted a divorce.
He did, yes.
So you were about to become the second ex-Mrs. Donaldson.
Well, I don't think we would have gone through with that, so I would disagree.
Okay. You say that you love working with the big cats?
Of course.
And they're your passion, correct?
Yes, absolutely.
Using your words, you call them your furry family?
Yes, that is how I refer to them.
Now, you started working at the Wild Wildlife after you married Lou Donaldson,
Correct.
and he was the owner of the Wild Wildlife.
Yes, and then we became co-owners.
Are you what you're saying? You became co-owners during your marriage?
Actually, if I recall correctly, we co-founded Wild Wildlife together.
Now, Ms. Beja, you remember giving a prior deposition in this matter
Yes, sir.
where you were asked questions and you answered them,
Absolutely.
where you rose your right hand and you swore to tell the truth.
Of course.
And you did tell the truth, correct?
I did.
And in that testimony, you gave a full and complete statement of the events that transpired.
Absolutely.
Now, isn't it true in your prior deposition, nowhere did you mention that you co-founded the Wild Wildlife with Lou Donaldson?
Is that right? I may have been mistaken. I do believe I co-founded Wild Wildlife, but perhaps my deposition says differently.
So for the record, this is your first time you're giving that testimony today.
No, I believe that I said I was a co-founder before.
Okay, moving along. You claim that you would never harm Lou Donaldson
Of course not.
or threaten him,
Of course.
but you are aware of a court record that was a court document that was filed against you.
I am aware.
And in that court document, you're aware of the claims that were within it.
I am aware of them.
And you are aware that there was a claim in that court document filed by Lou Donaldson that says you threatened to kill him.
I am aware of this claim that he made.
Your Honor, may we publish for the jury Plaintiff Exhibit 5 and 6 side by side?
For the,
redacted,
is that the will and the redacted
yes,
signature?
yes, the redacted.
Okay. You may.
Ms. Beja, do you see your screen here?
Yes, I can see it.
And do you see that signature on your left? The date where that was filed was June 12th, 2012. Am I reading that correctly?
Yes, that's correct.
Okay, and then referring your attention to that document on the left, this is the alleged will that you presented.
Exactly.
And the date on this one, if I'm reading it correctly, does that say June 14th, 2012?
Yes,
So these two documents were filed just 2 days apart from each other.
that's correct, sir.
Thank you, Ms. John. Ms. Beja, you've been listening to this whole trial,
Yes, sir.
and you heard Cam Donaldson testify about Lou Donaldson's other will,
I did.
which split his assets 4 ways.
Well, I don't believe this will exist, but I believe that's what she said, yes.
Right, Cam Donaldson said the assets were split 4 ways, correct?
Correct.
But the will you presented, it was not split 4 ways,
It was not.
or 2 ways.
No, it left all the estate to me.
Right, it left everything to you. Moving
Yes,
on,
sir.
Ms. Beja, you claim on direct that Mr. Donaldson was your soulmate.
Yes, of course.
So you loved him completely, correct?
Absolutely.
And you said that when he left, this was devastating for you.
Of course. I never remarried.
And on August 17th, 2012, you claim he went to Costa Rica?
That's potentially what happened. Yes.
According to you, he left unannounced in the past,
Yes, that's correct.
but he had always come back.
Of course.
But on this occurrence, just a day or so later, you filed him missing.
Yes. I mean, it didn't make sense for him to just be flying at 3 in the morning and never have called me. So I knew that something had gone wrong. So I knew I had to report.
So that's a yes, you filed him missing just a couple days later?
I reported him missing on the 18th. Yes, sir.
Okay. And you never checked to see if he made it to Costa Rica?
You mean, did I contact him? I don't understand the question.
Yes. You never tried to reach out to him to see if he made it to wherever he was going?
Oh, of course I tried to contact him.
Ms. Beja, you never tried to call him?
Yes, I did.
All right. You remember giving a prior deposition in this matter?
Yes, sir.
You asked questions and you answered them?
Of course.
And you rose your right hand and you swore to tell the truth.
Yes, and I take that very seriously, sir.
And you gave a full and complete statement of the events that transpired.
I answered the questions I was asked, yes.
Right. And nowhere in that deposition had you ever said you tried to contact Lou Donaldson after he was missing in any capacity.
That was not asked.
Your testimony here today is that you tried to contact him. That is the first time you've made that statement.
Yes.
Okay. So even though you claim you contacted him,
I wasn't able to contact him, but I attempted, sir.
but you were able to file him dead.
Yes, on the 18th. Oh, file him dead. My apologies. Yes, in 2017.
And you said you needed closure, right?
Absolutely. I'd waited for 5 years. I just couldn't go on like this, so I had to move forward.
But a divorce would have brought you closure, right?
You're referring to whether I should have accepted Lou's proposition for a divorce?
I'm saying you could have filed him dead, or you could have filed to have him legally divorced, and you chose legally dead, correct?
Well, yes, because I believe that he's dead, sir.
Well, because filing him dead allowed you to collect on his $5 million life insurance policy.
That's true. That is the result that would occur.
And then also officially inherit his $5 million estate.
Yes, wildlife is very important to me, and I wanted to continue that work.
Your Honor, no further questions.
I apologize. I haven't been muted for some time. Mr. Trevisani, do you have any redirect at this time?
Yes, Your Honor.
All right, please proceed. And if you can, keep it brief.
Ms. Beja, did you declare your husband dead so you could get his money?
No, I had to move on with my life. I'd waited for him for 5 years. I just needed a sense of closure.
Opposing counsel asked you a lot about your relationship in the weeks leading up to Lou's disappearance. So I want to ask, when Lou disappeared, what was the status of your relationship with him?
We were still married, still living together, still working together. We talked about our issues and we were trying to work through them.
And ma'am, I want to be absolutely clear on this point. Was there ever a restraining order that was granted in this case?
No, sir.
Thank you, Ms. Beja, excuse me. Your Honor, we have no further questions. Barring any recross, may Ms. Beja be excused?
I won't allow any recross in any circumstance. Mr. Mays, may Ms. Beja be excused?
Yes, she may, Your Honor.
Thank you, everyone. Ms. Beja, we appreciate you. Are there any further witnesses from the defense?
Yes, Your Honor. The defense calls Chris Renard.
All right. Ms. Renard, would you please raise your right hand? Do you swear to tell the truth?
I do.
All right. Thank you very much. And Mr. Ayers, please proceed.
Thank you, Your Honor. Good morning.
Good morning.
Can you see and hear me okay?
Yes, I can.
Please introduce yourself to the jury.
My name is Chris Renard.
What do you do for a living, Ms. Renard?
I'm a death claims investigator with the Summit Life Insurance Company.
How are you involved in today's case?
Well, I investigated the disappearance of Mr. Lou Donaldson.
Why were you investigating the disappearance of Lou Donaldson?
Because Karen Beja filed a claim for life insurance through Summit where I work, and so we wanted to see if we had a basis to deny that claim.
What would you need in order to deny that claim?
Well, if we found credible evidence that she was involved in Lou Donaldson's death.
Okay, before we talk about this investigation, I want the jury to get a sense of your qualifications. Can you describe your educational background?
Yes, I received a bachelor's degree in criminology, and then I also graduated from the police academy.
Where have you worked as an investigator?
Well, I first started my career with the Statesville Bureau of Investigations, and then I moved to the Summit Life Insurance Company, where I've been ever since.
So how many years total have you been working as an investigator?
23.
You described yourself earlier as a death claims investigator. Do you have specific training in investigating death claims?
I do. I receive annual training in death claims investigation.
Do you have experience interviewing witnesses?
Yes, I do.
Do you have experience reviewing documents?
I do.
Do you have experience investigating possible crimes?
Yes, I do.
Your Honor, we offer this witness as an expert in death claims investigations.
Ms. John?
Your Honor, I believe defense hasn't laid enough foundation specifically. She's an insurance claim investigator, so as long as it's death claims investigations related to insurance, we're okay.
Mr. Ayers?
That's exactly what we're offering her as, Your Honor. An investigator looking into deaths claims, so insurance claims related to deaths.
That's what I thought. So I'm going to allow that tender. And the expert, or Ms. Renard, is tendered as an expert in deaths claims, which is quite a difficult thing to say. Deaths claim, insurance, and so forth.
Thank you, Your Honor. Ms. Renard, let's talk about your investigation in this case. You said earlier that you were investigating the disappearance of Lou Donaldson. When you were looking into that, what possibilities did you investigate?
Well, I looked into two primary possibilities. The first one is the plaintiff's theory that Miss Beja had something to do with her husband's disappearance. And then the second one was the possibility that Mr. Donaldson accidentally crashed his plane somewhere in the ocean between Statesville and Costa Rica.
Well, let's talk about those one at a time. Let's start off with the plaintiff's theory that Karen Beja had something to do with her husband's disappearance. Why were you looking into this?
Well, in the event of Mr. Donaldson's death, Miss Beja would stand to receive about $10 million.
When you're investigating a theory like this, what sort of evidence do you look to?
Well, I'd look for any eyewitnesses that there might be, and then also any kind of physical evidence.
Let's talk about eyewitnesses. Did you interview people in this case?
I did. I spoke with several members of Mr. Donaldson's family, and then some of his friends and his business associates.
You said you talked to members of Lou Donaldson's family. Did you have a statement from the plaintiff, Cam Donaldson?
Yes, I did.
Did you have a statement at all from the sheriff's department?
I did. I have a contact there, and so I received some information about their investigation.
Outside of your interviews, what other evidence did you collect when you were investigating this possibility?
Well, I also looked at financial records, as well as the police reports and some photographs of Mr. Donaldson's car.
At the end of your investigation, what eyewitness evidence did you find linking Karen Beja to her husband's disappearance?
None.
At the end of your investigation, what physical evidence had you found linking Karen Beja to her husband's disappearance?
None.
So let's talk about that second possibility, the idea that Lou Donaldson could have died in a plane crash. Why were you investigating this?
Well, according to the plaintiff, Mr. Donaldson was a pilot and he often flew to Costa Rica.
When you were looking into this possibility, were there any particular pieces of evidence that you focused on?
Yes, I primarily focused on his van that was found.
Your Honor, may we republish what's already in evidence as Defense Exhibit A?
Yes.
Ms. Renard, have you seen this photo before?
Yes, this is the photo of Mr. Donaldson's van.
Now, why were you looking into the van?
Well, both because of where it was found and also because of what was found inside of it.
Where was it found?
It was found in an airstrip.
What was found inside it?
Mr. Donaldson's glasses.
Your Honor, may we republish what's already in evidence as Defense Exhibit B?
Yes, you may.
Ms. Renard, why were the glasses being inside the van significant to your investigation?
Well, the plaintiff has said that Mr. Donaldson wasn't used to flying without his glasses.
I want to push back on this idea of a plane crash slightly. In the course of your investigation, did you find any evidence of a flight plan or flight log filed by Lou Donaldson the weekend he disappeared?
No, I didn't find any actual flight log or flight plan, but I did find some evidence of why there might not actually be one.
What do you mean by that?
Well, Cam Donaldson said that her father's pilot license was suspended, but she says that instead of stop flying, he would just fly without documenting it.
You said earlier on that you reviewed some financial statements in the course of this investigation. Do you remember what financial statements you looked at?
Yes, I looked at Lou Donaldson's bank account statement from 2012 through 2017.
Your Honor, can we republish what's already in evidence as Plaintiff's Exhibit 4?
You may.
And Ms. Renard, was this bank record significant to your investigation into the possibility of Lou Donaldson dying in a plane crash?
Yes, it was.
Why?
Well, if he died in a plane crash that night, it would explain why his bank account activity suddenly stopped. As you can see, there are no transactions after August 8th or August 17th of 2012.
Thank you, Mr. Trevisani. Ms. Renard, at the end of your investigation, what did you do?
I had our insurance company pay out the life insurance claim to Miss Beja.
Thank you. Your Honor, I have no further questions at this time.
All right. Thank you, Mr. Ayers. Ms. John, do you have any questions?
Yes, Your Honor. But before may we approach?
Certainly.
Your Honor, we would just like to ask whether the restraining order at this time may be admitted, as opposing counsel in their redirect specifically asked the defendant whether a restraining order at any time had been filed and specifically approved or denied in front of the jury. Therefore, this even further lowers any prejudicial effect, as it has already come out that the defendant, Lou Donaldson, was threatening and intended to divorce the defendant, that he threatened her. So the prejudicial effect of this document and calling it a temporary restraining order is substantially lower than the probative value.
In response, Mr. Ayers?
Excuse me. Your Honor, this document is still substantially more prejudicial than it is probative. It's still a denied request for a temporary restraining order and may still confuse the jury as to what the evidence in this case actually is. The fact is, there isn't a temporary restraining order in this case. And my co-counsel asked if there was a temporary restraining order in this case. She answered truthfully that there wasn't. The probative value here is very low, as this temporary restraining order request was denied, and a court has already determined that the information contained therein was either not trustworthy or insufficient. And Your Honor has already stated that the evidence within that temporary restraining order request should only be used to rebut a witness's assertions, not for its truth value.
Mr. Ayers, I need you to help me recall something here. During your most recent direct examination, did you not ask if a temporary restraining order had been filed for?
For this witness, Your Honor, I asked nothing about a temporary restraining order of Chris Renard.
Your Honor, may I be heard as clarification. It was with the defendant herself during the redirect portion. It was asked whether a restraining order not only was filed, but denied. And the defendant on the stand in front of the jury testified that a restraining order was denied against her, not that it was admitted.
Mr. Trevisani?
Or filed.
I believe the record will show that the question that was asked to this witness is, was there a restraining order against her? To be clear, we believe opposing counsel has tried to confuse the jury on this issue. They're attempting to bring in this fact as if a restraining order was in fact granted. The question I asked Ms. Beja, she answered truthfully. There was no restraining order against her. I didn't ask if her husband had filed one, and I didn't ask if she knew of the existence of that being filed. I asked her if there was a restraining order against her. We haven't opened the door for this testimony.
All right. So here's the thing. I think it was close, Mr. Trevisani. Mr. Ayers, I think that you have gotten a little closer to that line than probably was preferential. I'm going to maintain the previous rulings that I have made in regards to that temporary restraining order. I do think that under 403, it is unduly prejudicial. I think that more importantly than it just being unduly prejudicial, it would risk confusing the jury pretty substantially. I have already ordered, I'm just clarifying for the record here and for all parties, that some, particularly the fact that there was a threat that was alluded to in there can be used to rebut some previous testimony that had been given by the defendant. We're past that point. So we really shouldn't be talking about this temporary restraining order at all anymore. Is that clear to everyone?
Yes, Your Honor.
Yes, Your Honor.
Of course, Your Honor.
Okay. Thank you, everyone. Please proceed.
Ms. Renard, you're here testifying as an expert in investigations.
Yes, in death claims investigations.
You reviewed the signature on Mr. Donaldson's alleged last will to determine whether it was authentic.
I did.
In reviewing a document for its authenticity, you'd agree it's important to be thorough,
Yeah, of course.
to consider all the evidence,
Yes,
and to approach the investigation without any biases or assumptions.
absolutely.
Something that can indicate a signature is inauthentic would be if one of the witnesses couldn't vouch for that authenticity.
That could be one thing that I might look at, yes.
And you spoke to the witnesses for the document the defendant presented.
I did.
Specifically, you spoke to Miss Samantha Lane.
Yes, I did.
You also received a letter from Samantha Lane.
Yes, I did.
Your Honor, I have a copy of a letter. May it be marked as Plaintiff Exhibit 7 for identification. And Ms. Renard, you have a copy of the exhibits in front of you.
Yes, I do.
And you have Plaintiff Exhibit 7 as well. You recognize it.
I do.
This is the letter you received.
Yes, it is.
This letter is in substantially the same condition as it was when you last reviewed it.
Yes, it is.
Your Honor, plaintiffs move Exhibit 7 into evidence.
Mr. Ayers?
I object to hearsay on this letter, Your Honor. May I be heard? While experts are certainly allowed to rely on otherwise inadmissible evidence in forming their conclusions, the standard under which an expert may enter that evidence, may present it in front of a jury, it's a far higher bar. They have to pass a reverse 403 test. In other words, the document in this case has to be substantially more probative than it is prejudicial. And that's not the case here, Your Honor.
Ms. John, can you please, and we're assuming this is all outside the presence of the jury. This is a bench conference. Ms. John, can you please give me an offer of proof for what's contained within this letter?
Yes, Your Honor. This letter is one, as the witness herself has admitted, she received, which is signed by Samantha Lane. This letter says that she was coerced into signing as a witness for the alleged will in question, and that she did not, in fact, see Lou Donaldson sign the will. And the probative value of this letter substantially outweighs any prejudicial effect, in that Miss Lane is one of two witnesses to the alleged will, the other being the defendant, who is inherently biased for this case, and the other is herself. So her testimony or this letter specifically, that she did not in fact witness the signature, is more probative.
Okay, I'm going to allow this to be admitted for two reasons. Number one, as Ms. John has already alluded to, I think it's appropriate on those grounds. Number two, the existence of such a letter and Ms. Renard having reviewed it in her death claims investigation can also go to Ms. Renard's credibility in that investigation. So I'm going to allow it on both of those grounds.
Your Honor, permission for my co-counsel to publish Exhibit 7 for the jury.
So granted.
Ms. Renard, so you spoke to Samantha Lane?
I did.
And then when you spoke to her, she told you the signature on Lou Donaldson's will was authentic.
Yes, she did.
Then after that conversation, you received this letter?
I did.
This letter said that, in fact, she didn't see Lou Donaldson sign the will.
That's what she said. Yep.
This letter said that she was coerced into signing as a witness.
That's what she said in her letter. Yes.
But according to you, this letter wasn't important to your analysis.
Not really. No.
In your words, you said this letter was a hoax.
Yes, that's what I believed.
And well, that's what you said, correct?
Yes.
And after you received this letter, you spoke to the defendant.
I did.
You told the defendant that there was an issue with Miss Lane and this letter you received.
Yes.
But after that conversation with the defendant, you attempted to get a hold of Miss Lane,
I did.
but you couldn't get a hold of her.
No, I was not able to get a hold of her.
You tried to call her and you couldn't reach her.
Yes, that's true.
In your words, it was as if she just vanished.
Right. I was never able to get a hold of her again.
Mr. Mays, you can go ahead and take this down. Now, I want to talk to you, Ms. Renard, about the documents that you did consider in your analysis. You compared the signature on Lou Donaldson's will, correct?
To what?
You compared that signature to other known and verified signatures from Mr. Donaldson?
Yes, I did.
Your Honor, I have a copy of Ms. Renard's signature comparison analysis form. May it be marked as Plaintiff Exhibit 8 for identification. Ms. Renard, do you have a copy of this document in front of you?
Yes, I do.
You recognize it?
I do.
This is your signature comparison analysis form.
Yep, it is.
And this is in substantially the same condition as it was when you created it.
It is.
Your Honor, plaintiffs offer or move Exhibit 8 into evidence.
Mr. Ayers?
No objection.
So granted.
Permission for my co-counsel to publish for the jury.
Permission granted.
Ms. Renard, this is your signature comparison form?
It is.
This first signature, that's from Lou Donaldson's life insurance paperwork.
Yes, that's correct.
The second signature is from his driver's license.
It is.
And the third signature is from the document the defendant presented as his alleged will.
Right.
Now, you don't know how old this driver's license signature is.
No, I guess not.
It could be 2 years old.
Yeah, whenever he got his driver's license.
Or it could be 10 years old.
Yep, I don't know when he got his driver's license.
Now, this life insurance paperwork signature, that's from 2005?
Yes, that sounds right.
So it was 12 years old when you used it.
Correct.
And Ms. Renard, you'd agree there's some differences between the first two signatures and the last signature on the alleged will.
Yes, there are.
And Mr. Mays, can you go ahead and zoom in on the notes section below? In your words, you can't say whether or not the signature on the alleged will is genuine or not genuine.
Yes, that's true.
In fact, there were enough differences that your overall finding regarding the authenticity of this signature was inconclusive.
Correct.
You can go ahead and take it down. And you'd agree that some reasons why a signature could be different, could be because of someone's age.
Yeah, of course.
It could be because of the pen they used.
Yep.
Or it could be because the signature was forged.
Could be.
And Your Honor, permission to publish for the jury what's already been admitted into evidence is Plaintiff Exhibit 6, the redacted version.
Go ahead.
And Ms. Renard, you're aware that Mr. Donaldson filed a document with the court just 2 days before he allegedly signed the will in question?
I am.
Well, you became aware of it today, correct? Because prior to today, you weren't aware of it.
Yes, I mean, I'm aware of it now.
That's right, but you weren't aware of it at the time you conducted your investigation.
No.
So which means you didn't consider it in your overall analysis.
No, I didn't.
And even though these documents are just 2 days apart, which means this is Mr. Donaldson's most recent signature available.
Yes, I guess it would be.
And Mr. Mays, you can take this down. Permission for my co-counsel to publish what's in evidence as Plaintiff Exhibit 5.
Go ahead.
Ms. Renard, in your investigation, you not only compared the signatures, but you looked at the document the defendant presented, this one on the screen.
Yes, I did.
And along with studying the signature, you studied the specific language in this document.
I did.
And you found a few wording choices in it suspicious.
Yes, I did.
Specifically the phrase, if I die or disappear.
Yes, that's something I hadn't seen before, but I don't know.
Well, you've been in the industry for 23 years?
I have.
In that time, you've looked at hundreds of wills.
Yeah, and like I said, this was unusual just because I hadn't seen it before.
That's right. In the hundreds of wills you've investigated, you've never seen that language.
No, I haven't.
No further questions, Your Honor.
Thank you, Ms. John. Mr. Ayers, any redirect?
Yes, Your Honor.
All right, please keep it brief.
Mr. Renard, you were asked about a letter signed with the name Samantha Lane. How much credit did you give that letter as a part of your analysis?
None. I didn't give it any credit.
Why not?
Well, I didn't find any evidence that it was in fact genuine.
Thank you, Ms. Renard. No further questions. May this witness be excused?
Ms. John?
Yes, no recross, Your Honor.
Okay. All right. Ms. Renard, thank you for your time. You may be excused. Does the defense have any further witnesses or evidence that it wishes to present to the court and the jury?
No, Your Honor. At this time, we rest our case in chief and request a brief recess before moving on to closing arguments.
All right. Was there perhaps a motion to be renewed?
No, Your Honor.
Okay. Well, let's.
Sorry. Prior to the recess, maybe please get a brief time check.
Sure. I think that that's appropriate. It's in the chat.
Yes. And Your Honor, at this time, plaintiff would also like to request 5 minutes for rebuttal.
Sorry, I just muted myself. So let's see. You have 25 minutes remaining. I'm going to prohibit you from using all 25 minutes for your closing argument. If you get close to that, I'll let you know. Does that seem right? So let's say if you, in some circumstance, use up 20 minutes, I will simply turn on my video. I'll raise my hand for 5 minutes. And will that be enough signal, or do you need something else?
No, Your Honor, we have no intention of using the full time. However, in conformity with the local rules in this jurisdiction, we need to request time for rebuttal ahead of time. So we just want to reserve the 5 minutes to be safe.
Oh yeah, that's fine. That's just fine. Mr. Ayers, any similar, well, you don't get a rebuttal. So never mind. So what we'll do here is, do the parties want a 10-minute recess before closing to gather themselves?
Yes, Your Honor, that would be great.
All right, great. So I'm just going to have everyone report back at 11:55, okay? Thank you, everyone. Hi, do we have everyone present?
Yes, Your Honor.
All right, and Ms. McManus, Mr. Braun, and Ms. Stackow, do we have all our jurors?
Yes.
Yes.
All right, fantastic. So the plaintiff has remaining 25 minutes and 56 seconds, and defense has 25 minutes and 42 seconds remaining. As I previously mentioned, I would request that everyone shut off their video and audio while the plaintiff and defense are presenting their respective closing arguments. Thank you, everyone. And Ms. John, you may proceed.
Thank you, Your Honor. Members of the jury, the facts you've heard and the evidence you've seen today may feel like a TV show, but Cam Donaldson's loss is very real. She lost her father, she lost her job, and she lost her inheritance. And the defendant still reaps the very real benefits from her actions. She created a crash to cover up a crime. She forged a will to secure a fortune, and she faked the scene to become Tiger Queen. Today, the issue for you to decide is, will the defendant be held responsible for her actions? As the judge will tell you, the plaintiff has the burden of proof in this case and must prove her claim by what the law calls a preponderance of evidence. To be clear, this is not beyond reasonable doubt, which is a standard you would normally see in a murder trial or on a TV show like Law and Order. That standard is significantly higher than what we have to prove in this case. In order to meet preponderance of the evidence, we only have to show that it's more true than not that the defendant intentionally or recklessly caused Lou Donaldson's death. What that means is, if we were to give you a scale, and on one side you weighed all the evidence we brought you today, and on the other side you weigh the defense's evidence. If that scale tilts in our favor, even by the slightest amount, then you must, not may, but must return a verdict in our favor. Today, that scale has tilted in our favor because the evidence has shown two things. First, that Lou Donaldson gave the defendant a better life. And second, that she killed him to keep it. So let's take a look at that first point, that Lou Donaldson gave the defendant a better life. You heard today that the defendant met Lou Donaldson when she was hitchhiking on the side of the road. She realized she had struck gold because he not only was a successful self-made businessman, but he was the owner of Wild Wildlife Emporium. And being with him would be her ticket out of poverty. Now, when they met, Lou Donaldson was married and had a child, but he was willing to give all of that up in order to pursue his relationship with the defendant. Being with Lou Donaldson gave her not only purpose, but it gave her the opportunity to live her dream life, taking care of the animals. But some years passed, and the defendant's spell over Lou Donaldson started to wear off, and he was threatening to leave her. Now, the defendant told you today, she said Lou Donaldson was her soulmate and that she loved him, but admitted that their marriage did have ups and downs. But members of the jury, they weren't just having relationship problems. Their relationship was deteriorating. You heard today that Cam Donaldson would frequently overhear Lou Donaldson and the defendant arguing. In fact, in the weeks leading up to his disappearance, Lou Donaldson was so shaken up by an argument he had with the defendant that he came out of his office and told Cam Donaldson, if anything happens to me, make sure the police look into Karen because she will be the one responsible for my death. Now, the defendants, they've tried to convince you that Lou Donaldson just upped and left to go to Costa Rica and that he had a mistress there. But there's no evidence to prove any of that. There's no love letters, there's no photos, just a convenient truth. And all this misdirection and stuff is just in an effort to confuse you. Because even if it were true, members of the jury, do you really believe the defendant found out her husband was having an affair with a woman in Costa Rica and she wasn't upset? No. Remember, just a few years ago, she was the other woman. This was deja vu, and she knew better than anyone else exactly how this story was going to end. The defendant was seeing her entire life flash in front of her. Lou Donaldson was done with her and done with their marriage. But there's no question here. Lou Donaldson's escape plan was to divorce her, not to disappear. The defendant realized she might leave this marriage exactly how she entered it, empty-handed. She was going to lose her husband, her cool cats and kittens, and the lifestyle that she'd grown accustomed to. And members of the jury, she wasn't going to let that happen. Which brings me to my second point, which is that the defendant killed Lou Donaldson in order to keep the life he gave her. Now, in a moment, we're going to unpack everything we know about Lou Donaldson's death. But before we discuss those things, I want to talk to you about what the law calls circumstantial evidence. As a judge will instruct you, you can and should equally consider both the direct and circumstantial evidence in this case. Circumstantial evidence means that facts can be proven based on the existence or non-existence of facts, which can be reasonably inferred. An example of circumstantial evidence would be if you walked outside and the ground was wet, all the cars were wet, the sky was gray, you wouldn't have needed to see the rain in order to reach the conclusion that it in fact was raining. So let's take a look at both the direct and circumstantial evidence in this case, starting with the timing of events and the defendant's own behavior. Mr. Mays, can you please share the timeline? You heard today that on June 12th, 2012, Lou Donaldson filed a document with the court. And you also heard testimony today from various people that Lou Donaldson was threatened by the defendant. Yet the defense expects you to believe that a mere 2 days after he filed a court document, that he signed this will that you saw today, which left everything to the defendant. Members of the jury, when you were picked to be here today, we asked you to leave behind your biases or assumptions. But we didn't ask you to leave behind your common sense. And your common sense tells you something about this story just isn't adding up. Then 2 months later, after this alleged will was signed, Lou Donaldson disappeared on August 17th of 2012. Then on the early morning hours of Sunday, August 19th, the defendant broke into the Wild Wildlife Emporium. Then on August 20th, she took over Lou Donaldson's company and shortly after fired Cam Donaldson. Then 5 years later, she requested to have the defendant or Lou Donaldson declared dead. And why is the timing of all of this so significant, members of the jury? Because you heard today, Lou Donaldson would leave town all the time, that he would go on trips without telling the defendant. But like she even told you today, Mr. Donaldson always came back. But this time, she declared him missing. This time, although she claims he went to Costa Rica on just the 17th, she took over his will, or she took his will. And this time, she took over his company. But she didn't give you a single reason why this time was any different. Members of the jury, that's because she knew this time was different. She knew Lou Donaldson wasn't coming back, and that's because she killed him. Now, the defendant, she does have an alibi for the night that Mr. Donaldson went missing. The cats and her brother. Yet, no one saw her with the cats. And as for her brother, a police officer who was on duty that night, when he picked her up, the transponder in his police car magically stopped working at that exact moment. And even her alibi, it only covers an hour of the night. So that means that the transponder is broken for that hour, And there's no one and nothing that can verify exactly where she was. And all this misdirection is the defendant's way to try and confuse you. And she further tried to mislead you by telling you that she and that same brother picked up Lou Donaldson's van and glasses at an airstrip just 40 miles away. Yet Lou Donaldson was blind as a bat without his glasses. So is it likely that he flew a plane without them? And members of the jury, most of us don't even go down the street to the grocery store without our keys and our glasses. Yet the defense expects you to believe that Lou Donaldson left the country without both of those things. All this misdirection was to ensure that she kept her cats and her cash. Now you heard today about Lou Donaldson's original will, which split his assets evenly in 4 ways amongst everyone and everything that he loved. Yet the document the defendant presented to you left everything to one person, herself. Mr. Mays, can you please share that document? Members of the jury, there are several reasons why you know this document is a fraudulent copy of Lou Donaldson's will. One of the main reasons, just look at the signature. You heard today from our expert, Taylor Pride, who told you that he compared and analyzed the signature on this document to other known and verified signatures from Lou Donaldson. When he compared those signatures, he concluded that the signature on this document wasn't Lou Donaldson's. He told you about the pen lifting, a common sign of forgery. He also told you about the quivering lines, which you can see for yourself. Yet again, another common sign of forgery. Now, the defense, they brought you the insurance investigator, Ms. Renard, who tried to insinuate that the signature on this document was authentic. But members of the jury, her opinion is entirely unreliable. She didn't even know about the court document that was filed just 2 days before this alleged will was signed. And because she didn't know about it, that means she didn't compare Mr. Donaldson's most recent and available signature to the signature on this document. She also chose to disregard the letter she received from Samantha Lane, which not only said that she never saw Lou Donaldson sign this document, but it also said that she was coerced into signing as a witness. And she's an expert in handwriting investigations, yet she didn't tell you that she even attempted to authenticate whether or not that letter was in fact Samantha Lane's. Instead, it didn't fit into her overall theory, so she just chose to disregard it. But wait, members of the jury, there's more. And I know I'm starting to sound like an infomercial at this point, but the list of problems with this document truly go on and on. Speaking of Samantha Lane, you heard today there were only 2 witnesses to this document, Miss Lane and the defendant herself. Yet you heard testimony from our expert, Taylor Pride, who said that when he spoke to Miss Lane, she said that she didn't see Lou Donaldson sign this document, and that she only signed as a witness because the defendant threatened to feed her to the cats if she didn't. And remember, this was the same threat you heard she gave to Exotic Bob earlier today. All this confusion and testimony was just the defendant's way to mislead you. But the red flags with this document still don't stop there. You heard from both the insurance investigator and our expert that the language contained within this document was suspicious. Specifically the phrase, "if I die or disappear." Each of them have reviewed hundreds of wills throughout their careers, and they have never once seen that language contained in a will before. Yet, in this case, Mr. Donaldson just so happened to disappear. So, you're left with a document that contains never before seen language, a clearly forged signature, where one witness said she was threatened with death, and the other witness is the sole beneficiary with 10 million reasons to kill. Members of the jury, your common sense tells you that this isn't Lou Donaldson's last will. The defendant realized she was going to lose everything. So she took matters into her own hands and killed Cam Donaldson in order to become the Tiger Queen. And in doing so, she left Cam Donaldson with absolutely nothing besides her own grief. Remember, at the beginning of this trial, my co-counsel, Mr. Mays, told you we would speak at the end about the value of Lou Donaldson's life and his relationship with his daughter, Cam Donaldson. As a judge, we'll instruct you, your job today is to not only consider everything that's happened in the past, but your job today is to look to the future. You're going to be tasked with assigning a value that attempts to compensate Cam Donaldson for the loss of her father. And members of the jury, we understand that that is an impossible ask because no amount of money is ever going to give this child her father back. Now, most kids, they grow up and see their parents once, maybe twice around the holidays, but not Cam Donaldson. She got to see her father every single day. They got to work together, building his passion project and working on the very thing he loved. And even after Lou Donaldson left her mother, day in and day out, Cam Donaldson stood by his side. They cared for each other deeply, but the defendant has robbed Cam Donaldson of many precious moments with her father. When Cam Donaldson gets married, there will be no father-daughter dance. When she has children, they're never going to get to meet their grandfather. There will be no more days at the Wild Wildlife Emporium, and Cam Donaldson will never get the chance to say goodbye. Today, you're going to be asked to assign a number to the missed Sunday dinners, the lost conversations, and the dad jokes that Cam Donaldson will never get to hear. What is that worth, members of the jury? $1 million? $2 million? $10 million? That's for you to decide. When these closing arguments are over, you're going to be presented with 2 verdict forms, but you only need to fill out one. Verdict form A. Mr. Mays, can you show them where they should sign? Sign your name on the bottom of this document and hold the defendant responsible for her actions. Return the only fair verdict that is consistent with the evidence and demanded by justice. A verdict in favor of Cam Donaldson.
Thank you, Ms. John. You have 8 minutes and 40 seconds remaining for any rebuttal that you would like to give. Mr. Trevisani, will you be doing the closing argument for the defense?
Yes, Your Honor.
Okay, thank you. Go ahead.
May I proceed, Your Honor?
You may. Thank you very much, Mr. Trevisani.
And Your Honor, before I begin, permission to publish any exhibits on screen that have been entered into evidence?
Yes, thank you for asking.
May it please the court. 2,969. That's how many days it's been since Lou Donaldson disappeared. And in 2,969 days, no one has found his body. Not the plaintiff, not the police, not the private eyes. Why? Because they were looking for a murder victim. Even after Lou Donaldson's van was found at an airstrip, no one considered the obvious. That when an aging man flies alone at night without his glasses, his plane might go down. That's why no one's found Lou Donaldson's body. You see, when someone's murdered, It's hard to hide a body. But when a plane goes down in the middle of the ocean, it's hard to find a body. Members of the jury, this was not a crime. It was a crash. Today, the plaintiff had the burden of proof. They had to prove every element of their case was more likely than not true. And today they failed. They failed because of two simple facts. So let's take them one at a time. This wasn't a crime. Today, the plaintiff spent a lot of time trying to convince you that Lou Donaldson is dead. No one disputes that. The question is how he died. Members of the jury, they had to prove that the defendant's actions, specific actions, caused Lou Donaldson to die. How are they trying to get over that hurdle? Well, in opposing counsel's closing argument, she told you that you needed to look past your biases in today's case. But then in their opening statement and in her closing, the plaintiff said, and I'm quoting here, Miss Beja was digging for gold. Members of the jury, that she got used to that rich lifestyle, that she wasn't ready to give it up. They presented a caricature of a gold-digging woman, the other woman, the second wife, and that's not the Miss Beja that we met today. She's a loving wife. She would give up all that money to have Lou back. She hasn't sold the company and took all the money from it. She's kept that wildlife center running, just like Lou Donaldson would have wanted. Members of the jury, it seems that the plaintiff is the one that needs you to rely on those base assumptions, those characters that we see on TV and in popular culture, but the law requires that you set those aside. Let's actually talk about the real evidence on the table here, because what did they present? We heard a lot of dramatic stories from the plaintiff today. They told you a story about how Lou Donaldson came out of his office and said, "If anything happens to me, go looking for Karen." Consider the source. Who's the only person that told you about that story? It was the plaintiff, who wants $10 million. We heard a story about a shouting match. We heard that story from the plaintiff, and the plaintiff alone, who wants $10 million. We heard another story from the plaintiff about this break-in at Wild Wildlife. Miss Beja was there. You heard her say there was a sketchy guy wearing dark clothes holding a lock cutter, that there were multiple police there. Members of the jury, only one of those four people was on the plaintiff's witness list today, and it was the plaintiff herself. Now, if you really think about it, this story about this break-in, it just doesn't add up. I mean, they presented this photograph. They said, look, this is proof that she had to have been there at 6 a.m., just like the plaintiff said. Members of the jury, who's missing from this photograph? Karen Beja. Thank you, Mr. Ayers. Members of the jury, why would she need to break in? What reason did she have? If she was the co-owner of the company, why would she go busting down doors and breaking locks? She wouldn't. So what did they do? They showed you a video of someone that claims that Miss Beja confessed. Members of the jury, the plaintiff's star witness, a person who literally calls himself Exotic Bob. Someone who couldn't take the stand and testify under oath here today because, well, he's in a prison cell. They presented no evidence to corroborate that spectacular claim, so they called Taylor Pride, an expert, to the stand. What did Mr. Pride talk about today? Well, he spoke at length about a will. This will right here. Members of the jury, I need to be clear here because this is not a forgery case. This is a wrongful death case. As opposing counsel said, they have to prove that the defendant is liable for her actions. If you're asking yourself, what actions of the defendant caused Lou Donaldson's death? Maybe I missed that. You didn't miss it, members of the jury. They never presented it. They said that Miss Beja's behavior was suspicious on August 17th. That, well, it's just completely unreasonable that she would have needed to get milk to tend for her tigers. But members of the jury, if Miss Beja was going to think years after the fact and invent a story about her whereabouts that night, don't you think she could have come up with something a little better? I mean, the plaintiff wants to have it both ways. On the one hand, she's a master criminal. She can make a body disappear without leaving a trace of evidence. But on the other hand, she's not smart enough to come up with a better alibi. I don't think so. Now, so far, I've focused on the evidence that the plaintiff tried to present today, but it's important to remember the evidence that they didn't present. Miss Beja was investigated thoroughly, not once, not twice, 3 times. First, the police, they came to her home, they searched every square inch. Then, the insurance company paid Chris Renard to look for any reason to deny Miss Beja's claim. Then the plaintiff's investigators looked into Lou Donaldson's disappearance. And what did they find pertaining to Miss Beja? What did all of these investigations have in common? They found zero, zip, zilch, nothing. Members of the jury, there are no eyewitnesses of a crime. No one took that stand and said they even saw Miss Beja and her husband together at all that weekend. There's certainly no physical evidence of a crime, no blood, no DNA, no fingerprints. Under oath today, the plaintiff's own witness told us we don't have the most basic elements of a crime here. There's no murder weapon because there wasn't a murder. There was no signs of a struggle because there was no struggle. There was no crime scene because there was no crime. Usually, when you accuse someone of killing another human being, you have evidence. At the very least, you have a theory. A theory is Colonel Mustard in the library with a revolver. Their theory is Karen Beja in the somewhere with the something. The plaintiff has failed to meet their burden. Now you might be asking yourself, if she didn't kill him, then what happened? If this wasn't a crime, then what was it? That brings us to fact number 2. This was a crash. Today we learned that Lou Donaldson loved to fly. He flew all the time, especially to Central America. And where did they find Lou Donaldson's van? That blue 89 Dodge Ram. They found it at an airstrip. This is actually the biggest clue that we have as to what happened the night that Lou went missing, because the plaintiff testified. When he drove that van away from work at 6 p.m. on August 17th, 2012, he left. That van was recovered at an airstrip. And Lou Donaldson, he was never seen again. Now, the plaintiff, they did their best to wave away this explanation of events. They talked about glasses. They said, well, Lou couldn't have flown without his glasses. He needed his glasses. Exactly. We agree. Lou needed those glasses to fly safely. And we know that when he flew that day, he didn't have them. They said, well, he didn't log a flight plan. There was no notice that he was going to Costa Rica. Members of the jury, that's what Lou Donaldson did. He would often leave the country and he wouldn't tell anyone until afterwards. He never, according to the plaintiff, never registered those planes. He never logged his flight plans. And what that means is that on August 17th, 2012, no one at that airstrip knew that Lou Donaldson needed help, and no one in the air knew to avoid him. They might say there's no plane missing. Members of the jury, we heard time and time again today, no one, not his wife, not his daughter, no one knew exactly how many planes Lou Donaldson had. We don't know if one of those planes is missing, if one of those planes is in the Gulf of Mexico right now. And the plaintiff's expert, they said, well, I sent people to Costa Rica and there's no evidence that Lou set foot in Costa Rica. We agree. Lou took off that night, but he never landed. Now, they might tell you there's no evidence of a plane crash. But the truth is, no one looked for evidence of a plane crash. The police searched here in Statesville. The plaintiff sent his people that worked for the private investigating firm all the way to Costa Rica, but no one searched the 2,200 miles in between. And the fact is, there is evidence. There's plenty of evidence of a plane crash in this case. A plane crash explains why there's no blood. A plane crash explains why there are no eyewitnesses. A plane crash explains why 8 years later, no one has found Lou Donaldson's body. All of the evidence that's missing from their theory, it's explained by ours. Now, in a moment, opposing counsel is going to come up here for rebuttal, and I expect that they will mock the idea of a plane crash. That's why it's critical to ask yourself, which is more likely? That a woman who cares for cats was able to pull off the murder of a century without leaving a speck, a trace of physical evidence, evading 3 different investigations? Or that an aging pilot flying alone, flying at night, flying without his license, flying 2,200 miles, flying without his glasses, didn't come home? I submit to you, members of the jury, that our version of events is far more likely. But we didn't have the burden in today's case. The plaintiff had the burden. Not a burden of rumors, not a burden of speculation, a burden of proof. Today, they failed to bring you that proof. We ask that you return a verdict in favor of Miss Beja, because this wasn't a crime. This was a crash. Thank you for your time.
Thank you, Mr. Trevisani. Ms. John, do you wish to present a rebuttal?
Yes, Your Honor.
Okay, please go ahead. Thank you.
Members of the jury, the defense just told you a lot about the crime, and they specifically focused on the fact that there is no body. And members of the jury, we agree with them. Unfortunately, we couldn't bring you Mr. Donaldson's body today. However, the explanation for that is clear. You saw today that the defendant has an alibi. So let's rewind in her story a little bit to the night of Lou Donaldson's disappearance. She claims that her brother picked her up from the side of the road and that he was with her and dropped her off at home. Members of the jury, that's your explanation right there. She was riding shotgun with her own personal how to get away with murder manual. Her brother, who works for the police department, mind you, the same police department which supposedly investigated Miss Bagia and the defendant in this case, he was with her the night of the murder, and conveniently, his transponder, which tracked his location, went offline. And it didn't just go offline for the hour they were together. No, the transponder was offline for several hours, more than enough time for them to not only dispose of the body, but to cover all their tracks. Also, more than enough time for them to plant the van at an airstrip that was 40 miles away. The defense showed you several pictures of that van which was found, and they showed you the glasses and the key. But did you hear any testimony today about how they knew where that van was? Did you hear that the police called the defendant and said, the van is at this location, go pick it up? No, that's because there is none, members of the jury. They expect you to believe that in the entire state of Statesville, they were just driving around, the same two people, the defendant and her brother, and they just so happened to stumble upon Mr. Donaldson's van with key pieces of evidence planted inside neatly on the driver's seat. Does that make sense, members of the jury? And now let's fast forward a little bit further in the story. You've heard a lot today that the defendant said she had a right to be there and that she was co-owner of the Wild Wildlife Emporium. Yet again, this is just another sign this isn't true. They made some mistakes and now they're trying to cover up their tracks. Because Cam Donaldson told you today that the Wild Wildlife Emporium was a place she worked at with her father for 20 years. Yet the defendant and Lou Donaldson have only been married for 12. So if you do the math, how could she have co-founded a company that she wasn't even around when it started? And also, if she was co-founder, why would she have needed to break in? You saw the alarm went off that night. You saw the photos. Mr. Mays, can you please publish? You saw this photo. If the defendant really was a co-owner, why didn't she just use the front door? Why didn't she dismantle the alarm? Why did she have to wait until after hours in the darkness of the night to go in and break into not her own office, not her husband's office, to break into Cam Donaldson's office? It's because there was a piece of evidence there that she needed in order to cover her tracks for her story to make sense. Speaking of made up stories, you heard a lot today about Costa Rica, and specifically this made up crash, which is where the defense has tried to suggest in what they call a theory that Lou Donaldson is in the ocean. But pause for a second and think about what they're really asking you to believe. They're asking you to believe that Lou Donaldson's body is in the middle of an ocean with absolutely no proof of that.
They didn't tell you today that the defendant received a call that said her husband was in the ocean. They didn't bring you any news articles about to support their theory or any probabilities of accidents or crashes that happened around that time. Yet, look at the timing of events here, members of the jury. Lou Donaldson supposedly got on his plane once again, like he always does, without telling the defendant he was going out of the country on August 17th. Yet, by August 19th, the defendant had declared him missing. Members of the jury, in less time that probably would have taken Lou Donaldson to fly to Costa Rica, the defendant declared him missing. She didn't tell you she heard a plane crash and she knew. She didn't tell you that she called her husband, he didn't answer, and that was a sign. She couldn't give you any information as to why she would have known that this time Lou Donaldson wasn't going to make it to Costa Rica. Members of the jury, that's because she knew there was a 0% chance Lou Donaldson even left to go there in the first place. There's no way she would have known to declare him missing, to take over his business, to present to you this forged will, unless she knew there was a 100% guarantee that Lou Donaldson would never return and that his body would never be found. Look at all the facts and the evidence that you do have in this case, and it's clear there's only one possible explanation. The defendant killed Lou Donaldson to become Tiger Queen, return the only fair verdict that is consistent with the evidence and demanded by justice, a verdict in favor of Cam Donaldson.
Thank you, Ms. John. All parties can turn their cameras back on. I want to thank everyone at this time and congratulate you on completing this round of this tournament. I think that everyone's use of technology has been pretty impressive. You know, we are all having to adapt in these strange times, and you all did very, very well. I also want to thank our jurors for their time today. Ms. Stackow, Mr. Braun, and Ms. McManus, thank you so much for spending your Saturday morning assessing these folks for their advocacy skills. We're not allowed to do feedback. I would love to, but we're not supposed to do it in this setting here. So I'm just going to release y'all with a thanks and with a congratulations. I hope that you're able to enjoy the rest of your day. And just great work, everyone. It was nice to meet y'all.
Thank you, Your Honor.
Thank you.
Of course. Take care.